Yeah, well, you know what? I think of deciding different owner, whether he's an owner, lives in Woodland Park, or he lives in Divide, or lives in Colorado Springs. He's not a resident of the property. He's not a resident of the property. Okay.
6:30, I call to order the Thursday, September 22nd, 2022 Woodland Park Planning Commission meeting. Take roll call, please.
Chairman Hartsfield,
Here.
Lee Brown,
Here.
Carol Harvey.
Here.
Ken Kennedy,
Here.
Larry Larson,
Here.
and Sean Nielsen is absent.
Very good. Mr. Kennedy is joining us via Zoom. Please join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Next item on our agenda is approval of minutes. We have two sets of minutes, one from the June 9th meeting and one from the August 25th meeting. So to address the June 9th meeting, are there any corrections or clarifications that are requested? Seeing none. All in favor of approving the minutes, say aye.
Aye.
Any opposed?
I should abstain perhaps from being absent.
Very good. Minutes are approved. Then moving forward to the August 25th meeting, any comments or clarifications requested? Seeing none, also all in favor of approving the minutes? Aye.
Aye.
Any opposed?
And abstain.
Very good. Those minutes are approved as submitted. Thank you. Takes us to public hearings. We do have a number of people in the audience tonight. Our first item on the agenda is our only item is to consider an ordinance for Title 5 and 18 of the Woodland Park Municipal Code concerning business regulating and zoning to license and regulate short-term rentals. And a little note on the procedures for this evening. We will have a presentation by staff, and then we will open up to public comment. And we'll ask you to sign up on the list in the back. We'll go through that list. And if there's any further comments, somebody hasn't signed up, we'll entertain them. You'll need to come up to the podium, state your name and address. And we are going to limit comments to 3 minutes per person this time. Please make your comments unique. We don't want to have a lot of repetitive statements. You can refer to somebody's prior statement, but please keep your comments new and on topic. We also take anyone online, comments from them. After that point, we will close public hearing and have discussion among council members, ask questions of staff as necessary, and then move forward with any motions that may be appropriate. With that, Karen, I'd like to turn it over to you. You have a presentation for us.
I do. I'm working on the share screen feature here. And I do have a number of slides to go through to provide a more thorough overview of the ordinance. I know planning commission members have been involved in a number of work sessions, so this may be rather repetitive for you all, but just to make sure everybody in the audience is caught up to the things that we've been looking at. Like I said, there is a number of slides to go through here. So the chair has already announced the title of the ordinance that's been drafted for your consideration. And in terms of how we got here, it was over a year ago when this issue was identified. And short-term rentals are broadly defined as renting of either a part of a residence or the whole residence for less than 30 days. And current city zoning regulations do not explicitly address this type of rental in any zoning district. And for that matter, we don't address even long-term rentals. And that's how you've typically seen houses or residential units rented, 6-month lease, 12-month lease, something like that. Sometimes 30 days with an option to renew on a monthly basis. So the concept of renting for a time period, a house or a room in a house for a time period of less than 30 days is somewhat newer and has really grown in recent years. And so tonight's topic is a legislative item, since this would be a code change that would pertain to properties throughout the city. It is not a quasi-judicial item, which would be something that pertains to one specific property. And to date, we have received a couple of written comments, especially since the last work session. Those have all been forwarded to the Planning Commission for their review as part of preparing for this meeting. Within our current regulations, we already have in place a lodging tax, and that specifically calls out the need to collect this tax when a room in any type of rental unit, like a hotel, motel room, apartment, lodging, in-room, guest house, any of those type of things is rented or leased for less than 30 consecutive days. And the city already has in place business license requirements in Title V. And we had been issuing business licenses for folks who engaged in this type of business operating a short-term rental. So timeline in more detail, it was in November of 21, staff started with one-on-one interviews with stakeholders throughout the community to get a feel for the variety of issues and concerns and pluses and minuses associated with this kind of a use. And then it was in May of this year where City Council and Planning Commission had their first joint work session on the topic, where the findings of those one-on-one stakeholder interviews were outlined. In June, the city had an online community questionnaire. And then July 6th, we held 2 community conversation events at the UPass Cultural Center and obtained a good deal of feedback related to a number of nuances, pluses, minuses. We heard from operators, neighbors, all kinds of folks were on this particular topic. And then it was July 7th at a city council meeting where they adopted a 90-day moratorium through ordinance number 1426, prohibiting the issuance of business licenses for short-term rentals. And then later that month, City Council and Planning Commission had another joint work session, August 18th, another joint work session. And it was through those where we were really trying to drill down into the findings, or what we heard from the community conversations, what was most important, what were the things we most wanted to see in an ordinance that would address all those community concerns. And then after that, it was most recently on September 8th when the Planning Commission had a solo work session where they really worked to finesse the ordinance, and that's what's in front of you this evening. So the whole result or objective through this whole timeline was to build consensus as best we could on how to address STRs within the city code. So the ordinance objectives are spelled out up front in the whereas statements of the ordinance. And the bottom line is the objective is to protect residential integrity and community character within the city, to adopt license regulations and restrictions on the renting or leasing of real property for occupancies of less than 30 days, to ensure clarity, increased enforcement, fairness, and consistency with the goals of the city for its residents and businesses and customers. And then with regard to the subject regulations concerning short-term rentals, that they're necessary for the health, safety, and welfare of the public and to prevent adverse impacts to adjacent properties, neighborhoods, and quality long-term rental housing units within the city. So within the ordinance, there are a couple of definitions that are being added. These appear in the proposed section 5.22.010, which relates to the licensing. And then anything under section 18 is going to be in the zoning regulations. And so a couple of these definitions appear in both places. And I believe applicant and lodging tax only appear in the business licensing section, so Title V. So those are spelled out very clearly in terms of who an applicant is, what a short-term rental business is, what a short-term rental unit is, and then that reference back to lodging tax that was already on the books that gets collected. So the next section in the proposed ordinance deals with licensing limitations and requirements. So the licenses are going to be required for somebody who wants to operate a short-term rental business. The number of the license that gets issued must be included in the title of the listing on all public advertising, including but not limited to web hosting services. Short-term rental business license may only be issued to owners of properties, as they're listed on the recorded deed for the property, and who are also one of the following. So there's criteria there in terms of being a natural person, a trust, and then a business entity. And then the applicant for the STR license must also possess at least a 50% fee simple ownership in the property. There's next a section that addresses caps on the number of licenses that can be issued. These are established or proposed to be established by zone district. And so suburban residential is a single family residential zone district, and urban residential is a single family zoning districts. The planned unit development that can have a variety of housing types. MFS stands for multifamily suburban, MFU is multifamily urban zone district, and then MHP is a mobile home park. There's no caps or maximum number of STR business licenses applicable within the neighborhood commercial, community commercial, service commercial, and CBD zoning districts. And then they're going to be prohibited in the agricultural and the public service public land zone district and the heavy service commercial light industrial zone district. And the caps that are proposed here were based on a survey of all existing dwelling units located within each of those zone districts. And going forward, that'll be reviewed on an annual basis on a calendar year and adjusted as the number of properties in a zone district grows, or the number of dwelling units within the zone district grows. There's a requirement for a local contact person. This is someone to be responsive and ensure compliance with provisions of the code. And some of those are things that a homeowner would more typically take care of themselves if they're in the unit. So they're not limited to removal of snow and ice, trash and refuse, other property maintenance kind of things. There's good neighbor guidelines that are being proposed. They're not in this ordinance. There'd be a separate document. And then making sure that they're in compliance as those things evolve over time. This person needs to be available 24 hours a day, 7 days a week. They need to respond within 60 minutes to any issues or concerns or complaints. And then they need to take action to resolve those issues, concerns, and complaints. Other standards spelled out in the ordinance is STRs are prohibited from operating without a business license within an accessory dwelling unit, an apartment or rental apartment unit, apartment buildings, dormitories, bed and breakfast establishments, campgrounds, RV parks, hotels, motels, mobile homes, and recreational vehicles, which includes all vehicles that bear a VIN number, tents, teepees, campers, and other temporary structures. There's also a requirement for a 500-foot separation between short-term rental units within the suburban residential, urban residential, and PUD zoning districts. And then there's a requirement to provide adequate parking for all of the guests and owners' cars for a particular property. Folks are going to need to apply 30 days in advance of wanting to operate a short-term rental. The license is good for 1 calendar year, and they must keep the information on their license up to date, and licenses are not transferable. There is a criteria spelled out under which a license will be issued, that the application is complete, that the application fees are paid and all other taxes are current, that the applicable requirements that are being spelled out within the ordinance, both under the business license or the short-term rental license section and the zoning ordinance, are met. And then the appropriate documentation has been provided. And then that there's no current or pending violations of the provisions of this Title V, Title 18, or any other laws or regulations in place here in the city. Those same criteria are very similar, apply for when somebody wants to renew their application. But there is also a couple of requirements that are added, and that is that no outstanding health and safety violations on the property are there. In that the property's in good condition under the buildings and construction section of the code, and that within the last 12 months, there's been no more than 1 violation of provisions of the ordinance or anything relating to short-term rentals. And then within the last 12 months, there's been no more than 1 violation of the provisions of the short-term rental business license or application requirements. There is a section of the code to address revocation and suspension, and specifically a license may be suspended or revoked by the city council after they would conduct a public hearing related to any suspected and reported violation. And reasons for suspension or revocation are spelled out. Those include failure to pay the lodging tax or any other tax, or the annual licensing fee, a false statement of material fact contained in the application, failure to file any report or provide or furnish any other information that may be required. If any fact or condition exists, which if it had existed or had been known to exist at the time of the application for the STR license, that would have been grounds for refusal of the issuance of that license. And then a violation of any provision of the chapter or law regulation pertaining to the regulation of STRs or the good neighbor provisions. There is a penalties section. While a fine is not specified here, it would be set through a separate resolution. And then in the section that lands, or the provisions that land within the zoning regulations, some of you may be aware that there's a table of uses in those zoning regulations. And this is what the proposal is in terms of what will be added to that table. Short-term rental units are listed as being permitted conditionally in the zone districts designated there. And what that means is, yes, you can do that use in that zone district, but there's also that other note over here in the lower left corner that says in accordance with chapter 522 and section 18.78050. So those are all those other standards that we're talking about, that those have to be met as a part of being able to potentially have this use in the zone district. And then additionally spelled out within the zoning regulations, there's standards here that the planning office would be looking at related to short-term rental units, that they're not permitted in a rental apartment or an apartment building in any time in any zoning district. Short-term rentals are not permitted in accessory dwelling units, bed and breakfast establishments, dormitories, campgrounds, RV parks, hotels, motels, mobile homes, recreational vehicles, which include, it's the same list that earlier showed up under the Title V. Nor short-term rentals should be operated in a way that would constitute a nuisance. The maximum number of occupants permitted in the STR shall be established at the time of the initial licensing. Large events such as concerts, parties, and weddings are prohibited. And then the fact that the designated parking for vehicles for the unit guests need to be outlined up front as part of the licensing stage. And then at the end of the ordinance, there's some provisions related to a transition into this ordinance and then the effective date. So for the first 2 months after the effective date of the ordinance, if the number of short-term rental business license applications submitted exceeds the cap imposed by the ordinance, the city shall process applications from the current short-term rental business license holders first before processing subsequent short-term rental business license applications. And then short-term rental business licenses granted here at the end of this year and those application fees paid. So any those that fall here within the end of 2022, that puts that license in effect until and through December 31st of 2023. After that, it will be a calendar year renewal. And then the ordinance will go into effect after its appropriate publication as required. So with that, the final recommendation is that should Planning Commission find the provisions of the proposed ordinance satisfactory, that you recommend City Council approve the code amendments as presented. So that's what I had for you this evening.
Well, thank you. Appreciate that presentation. I guess I'd entertain any questions from council or commission to staff at this time. Opportunity for further discussion after public comment. Anything pertinent at this time?
I will make some comments after public comment.
Very good. Mr. Kennedy, you're out there?
Yes, I do have one comment before we start the public comment section that I'd just like to make. The percentages that are listed in the ordinance are similar to the percentages that we had in a presentation a while back. And just so people know what those percentages mean, the chart that we received in our PowerPoint presentation that showed our current percentages for the different residential zones, the ordinance has 8% for urban residential. The current build out percentage of short-term rentals is 7.26%. The suburban residential has 4% in the ordinance. The current percentage of build out of STRs is 4.76%. The planned unit development is currently at 3.24%. The ordinance shows 4%. And multifamily urban is 2% in the ordinance, and it's 1.77% currently. The multifamily suburban is, let me check the ordinance again, but the current percent of the build out was 4.64%. And so in looking at the math with what the ordinance provides, there would be an opportunity for 4 additional short-term rentals in the urban residential, no additional short-term rentals in suburban residential, 2 additional short-term rentals in planned unit developments, and no additional short-term rentals in multifamily urban or multifamily suburban with the ordinance as currently stated for those percentages. And those have just been picked, and I would advise that City Council will have to consider what those percentages need to be if they need to be altered. But those are the numbers if you do the math, just so people know.
Mr. Chairman, just to supplement that too, Ken, I don't know if you have the right draft in front of you, but the MFS and MFU numbers as written in the proposed ordinance, I think are swapped. List MFS is 2%, MFU is 4%. I think the intent is the other way around, MFS 4 and MFU 2.
Yeah, you're correct.
Okay.
I think because multifamily urban is at 1.77 and multifamily suburban is at 4.64, very similar to suburban residential at 4.76. So let's make a note for that as a comment for later. Thank you.
Any other comments or questions for staff this time?
No, the comment I would make though is just so those in the audience will understand that those percentages are on eligible properties as of the date of this ordinance. As more eligible properties came into existence within the city limits, then those percentages could be changed by the city council. Correct?
I don't know if the percentage changed, but the number of licenses could fluctuate within
Correct.
that same percentage.
That's correct. As
What
the unit,
I started to say, Ken, what I don't believe is addressed in this ordinance is how that fluctuation would be addressed. Would it be addressed by the city council? Or would the planning department have that?
It's spelled
Authority.
out within that same paragraph G. Further down in there, it goes into how that inventory is looked, that and paragraph H. Okay, right under it. So it is in the ordinance.
Anything else this time? Very good. David, do we have a signature sign-up list? Thank you. Before we proceed with the public hearing portion of this meeting, I do want to reemphasize, we're going to limit presentations by public to 3 minutes. And we will address any questions or comments at our leisure after discussion. And again, if your comments have been stated before, I appreciate it if we don't repeat comments in subsequent presentations. So first on our list is Mr. Tom Farrell.
I was probably number 3, if I recall, according to that sign-in sheet.
According to the sign-up sheet, you are number 1 and the first person on the list has been crossed off. I guess we will. Well, go ahead, Mr. Farrell, then we can go back to the top of the list, move forward. Thank you.
Have a slide, please.
Oh, yep, sorry about that. Here you go.
And so I'm Tom Farrell. We live in Woodland Park. SDRs are fairly new to our own community. Back in the old days.
Mr. Farrell, if you can address the commission, we appreciate that.
Oh, okay, excuse me. So SDRs are a recent phenomenon. They did not exist when most zoning ordinances were created. In my view, it's a conflict with the quality of life in Woodland Park. My wife and I moved here in 2019 from Colorado Springs for the simple reason that it's a quiet, beautiful community with friendly folks and less traffic and other things. The SDRs essentially favor the non-resident investors, no dog in the fight. And in my view, STRs will disrupt a neighborhood with perhaps crime, noise, congestion. And they also compete with our hotels and B&Bs. As a side comment to the group, Bloomberg says that Airbnb spends $50 million a year per year to make things right for guests that stay in their facilities. So they basically pay off victims, i.e. sexual crime, other things, and it's kept quiet. So you don't hear those things on the media or on the print media either. So the city of New Orleans back in 2016 was the poster child for Airbnb, but now the officials say that the surge in SDRs exacerbate the affordable housing crisis. Now, as I mentioned, we moved from the Colorado Springs area. We used to live in the Peregrine area, northwestern part of the city, up by the Air Force Academy. So back in back in 2014, we had some of our residents were basically renting out their homes. What we had found, because we have a very well organized HOA, what we had found, it was large numbers of cars, noise, drunken people, some smoking dope. The police had to be called several times. So what we did as a HOA down in the area is to hire a lawyer, and we amended our covenants, which in fact prohibited any STRs as well as the marijuana use. So I would just say, please stop the short-term rental invasion. Thank you.
Thank you. Next on our list is Francis Maria Snell, excuse me.
And then just for general reference, Mr. Farrell was right at 3 minutes. He
It's
was
very
like 30
good.
seconds, or I'm sorry, like a nanosecond away from my beeper going off. So just to kind of help you all gauge what that looks like.
At the last meeting, I brought up the issue of conflict of interest, and I asked each and every one of you to consider whether or not you have a conflict of interest, past, present, or potentially future. That hasn't been answered, and if you do, then you must recuse yourself. If I may, I have brought copies that are demonstrative of what I'm going to be saying this evening. And if I may approach, I'll pass those out to the council, to the planning commission members.
Oh, very good. Your time is still running.
Thank you. May my time stop while I'm walking?
No.
All right, since I had to use some of my time in walking to provide you with this statement, I will just summarize and go very, very quickly. I have been a citizen of Woodland Park for more than 12 years. I agree with Mr. Farrell that almost all of us have moved up here because it is a mountain town consistent with the comprehensive plan. It's blatantly, the commission has blatantly disregarded the comprehensive plan, and that disturbs me. STRs are currently illegal in the city of Woodland Park, and that's because within the four corners of the ordinances, what is not permitted is, it contains what is permitted. If it's not there, it's not permitted. It's disturbing to me that licenses have already been issued, and there have been people going rogue and making their homes STRs, and that they're never going to be found unless neighbors report them. And I think that's terrible. Council members, Labar, okay, I'm sorry, let me go back. All of my statements are consistent with Mr. Farrell that we have to stop short-term rentals, STRs, in the city of Woodland Park for the reasons that he has stated. I am completely against it. Some of my statements are, if you do approve it, you have missed a whole bunch of stuff in your due diligence, and I have made a list of those under number 5. City council members Labar, Case, and Neal must recuse themselves, and therefore there isn't a quorum. And so this is dead in the water. We can have as many meetings with the planning commission, but if there is no quorum because of conflict of interest, there's no way that this is going to pass.
Okay, your time is up, so I'll give you the opportunity. One last statement.
The existing moratorium must be extended because there's no quorum, nor is it possible to have a quorum. SDRs are detrimental to the city of Woodland Park. The city has failed to consider the comprehensive plan, property values, compliance with the Americans with Disabilities Act, the school budget and federal allowances for students, the out-of-state ownership of which will drive the housing prices up. For 12 years, we've been talking about affordable housing, and that's just been all lip service
Right. Well,
in my
thank you for
opinion
your
and the
comments.
opinion of others. And I will leave the rest to you, and hopefully you will read what you have failed to do in terms of your due diligence. You didn't even read our neighbor Cripple Creek's ordinance, which, if we have to have STRs, is a fabulous ordinance.
Thank you.
And the 3-minute, based upon the length of the presentation, the 3-minute limit for us to talk is absolutely egregious. Thank you. Have a
Gary Brown.
I'm Gary Brown. I am not a resident of Woodland Park, I'm a resident of Green Mountain Falls. And we are struggling with STRs. The issue with short-term rentals is that they are growing in so many communities at an alarming rate. Investors are purchasing homes in desirable areas simply because the potential return on investment is so attractive. Communities absolutely need to get out in front of this problem before it becomes unmanageable. Now, the permanent residents of any community deserve to retain their quality of life. Now, we're starting in Green Mountain Falls to become aware of this. And a great start for us would be to determine how many properties are being utilized as short-term rentals. The city thinks we have a limit of 60. I will assure you that we have many, many more than that. And we might have 120. It could be double that. These people are operating under the radar, which denies the town license revenue and probably violates some statute. Additionally, we have law enforcement, and we should be able to deal with this, but we have not. It has been suggested that we publish a list of rules and furnish those rules to every STR property owner. At a minimum, the list should include the following: the latest permissible arrival time so that vehicle lights aren't awakening residents at late hours. Appropriate parking should be there so we don't have everything jammed up. And I, for what it's worth, have STRs above me and on two sides of me, and it is not pleasant. Noise and light restrictions that protect residents from irresponsible behavior. Late night parties, yelling, children on rooftops are in this group. And yes, we've experienced all of those. I got the kids off the roof because I didn't want them injured. We've also been threatened by some STR guests. That's not acceptable. Reasonable limits of how many occupants to be in a property. I see these things advertised. They're 2 bedrooms and it says accommodates 8 people. Come on, that's not right. And finally, a notice given to every owner that law enforcement will be called when needed. There needs to be a mechanism in place to sanction the properties that cause repeated problems. There should be a limit to how many problems on an STR can occur in a given time. And all residents in the community should know how to make that report. An appropriate response, and you've covered this in your paperwork, should be suspension or revocation of the STR license. Now, why should communities,
Stop.
are we through?
Yeah,
Yeah, your time.
unfortunately.
So if you could summarize briefly or
Say again?
closing statement.
Just proactivity on the part of the community is all that will preserve the safety and the quality of life for the residents. And I thank you for your consideration.
Thank you, Mr. Brown.
I would like to ask Mr. Brown, have you seen a draft of the ordinance?
I have,
Okay, a
And-
lot of those issues are
and for
addressed.
what it's worth, I am very impressed with the draft. You've covered a lot of issues that we hadn't thought about and haven't discussed. So I hope you proceed with that.
Thank you.
Thank you for your time.
Mr. Penland.
Sure.
My name is Jerry Pendleton. I live on Masters Drive here in Woodland Park. Since she was cut off, I'm going to go along with the conflict of interest also. I'm going to talk in general only about possible conflict of interest right here in Woodland Park. What expertise do I have to talk about conflicts of interest? During part of my over 35-year career working for the Department of Defense, I negotiated several $100 million worth of federal government contracts. During that time, I also volunteered to teach AE contracting, architect engineer contracting, and professional services to government negotiators and private industry company officials. I taught courses from Korea to Germany and all over the United States. One section I taught and actually used several times pursuing conflicts of interest charges against government employees was about conflicts of interest. What if an elected official or appointed official of our city, including city staff, do not disclose that they or their immediate family members have a conflict of interest in dealing with a municipal matter, but we, the public, knows there's a conflict of interest? How do we get our voices heard at our public meetings? Here in Woodland Park, we don't get our voices heard. It's an honor system where the elected or appointed members recuse themselves or their fellow members force a recusal from their seated peer. A couple of years ago, I was told that our city conflicts of interest were none of my business. That's internal business with the city leadership. It's not my concern. I wasn't even allowed to discuss what appeared to me to be a definite conflict of interest. So assuming that's still the case, this will only be a general discussion. Exactly what is a conflict of interest? The dictionary definition is pretty simple. A situation in which a person is in a position to derive personal benefit from actions or decisions made in their official capacity. Anybody can easily understand when there's a conflict of interest among the folks who are discussing and making important decisions on our behalf. The only real question that needs to be answered, does someone or their immediate family members involved in the decision have a personal or financial interest in the results of the decision? It's really pretty simple. Our municipal code here in Woodland Park covers conflicts of interest and directs what is to happen when there is a conflict of interest. Basically, if an officer of the city or employee believes that for whatever reason, their involvement will have the appearance of impropriety, that is a conflict of interest, they must disclose that and not attempt to influence or vote on anything pertaining to the matter. However, it's not just the officer or employee. So it's not so simple after all. The mandate to disclose and recluse for the Woodland Park Municipal Code also extends to immediate family members. Okay, immediate family members are defined here in Woodland Park as
Mr.
husband.
Penland, your time is up. If you have a closing statement. Thank you. Mike Steiner. Steiner.
Good evening. Mike Stinner, 1140 Michael Lane, Woodland Park. I'd like to cede my time to Mr. Penland.
Very good.
Thank you.
Before Mr.
No.
Penland speaks, Jerry, did you read the new charter amendment Conflict of interest.
Yes,
is-
this came from the new charter amendment, and you'll
Yeah.
see that right now.
Okay,
Okay?
want to make sure because it added 5 pages to the
It-
charter.
Yes, it did. It went from 1 paragraph to 5 pages. Immediate family members are defined here in Woodland Park as husband, wife, son, daughter, mother, father, stepson, stepdaughter, stepmother, stepfather, father or mother-in-law, son or daughter-in-law, brother or sister-in-law, grandmother, grandfather, grandchildren, brother, sister, domestic partner, and even a few more. How does anybody determine that every single one of their immediate family members do not have a conflict of interest? As a general observation, we already have conflict of interest with this STR action. Conflicts that are clearly known to many of us citizens. A recent list of licensed and pending STR licenses has a total of 209 entities on the list, 34 named individuals, 85 LLCs, and 90 other businesses. If an officer of the city or any of their immediate family members have interests associated with an existing license to operate a short-term rental, or if they are on the pending list for an STR license, obviously for financial gain, that person has a conflict of interest and should have immediately recused themselves from even talking and possibly voting on the matter. If a conflict of interest is confirmed, the city's actions are compromised. However, there's a simple way for the city to correct this oversight. In this particular SDR, possible conflict of interest do not need to be a problem because the definitions of the words and our zoning use table currently already mandates what many citizens that I've talked with wants to happen with the short-term rentals here in Woodland Park. The words I refer to are residence, and STR is not a residence that belongs in our neighborhoods. Dwelling, and STR is not a dwelling that belongs in our neighborhoods. Lodging business for profit. That's exactly what an STR is. It's a business. You just mentioned a minute ago, our STR licenses are business licenses in our neighborhoods. Our current ordinances and zoning use table only allows STRs and other lodging businesses in our commercial zoned areas. What the city of Woodland Park has been doing by licensing the STRs is to allow lodging businesses to operate in our residential neighborhoods. This is a breach of our own zoning codes and an egregious government overreach. The city government is reaching down into our residential neighborhoods and forcing us to tolerate an unallowed, non-permittable commercial operation right next door to our homes. It's a violation of our property rights that you want to continue by way of this proposed new STR ordinance as it's currently written. Let's do the right thing, which is to stop this action and simply enforce our current ordinances.
Thank you, Mr. Penley.
I personally really appreciate your time and efforts to help protect the character of our family-focused residential neighborhoods. Thank you.
All right, Dave Paul.
Good evening, and thank you all for volunteering to put yourselves in this sort of a position. I am in agreement with
Your address, please.
Woodland West, Rutgers Place. Woodland Park taxpayer, I buy my groceries here. The concept of a short-term rental being any different than any other hotel or lodging or inn or bed and breakfast is kind of ridiculous. It is advertised on the internet. You order your room just like you do at a Holiday Inn. Yet by creating this carve out for short-term rentals, you're creating unfair competition and you're not collecting the proper taxes. This is a commercial business enterprise. It should pay commercial taxes. The bottom line is the incremental difference is there for a purpose. These businesses, these commercial entities create more impacts. They should have to pay for those impacts. If they don't, everyone else is subsidizing them. You need to think about that. In the presentation, I'd like to see numbers instead of percentages. How many actual units? Currently would be fine. I think there's a lot of question marks for me on who's going to be verifying these things. Is the city going to hire 3 inspectors? Are they going to, are these businesses going to be subjected to the same level of scrutiny as a hotel or a lodge that's open to the public and in a commercial zone? Ultimately, I think the biggest question is, why did this happen? An ordinance has the power of law. These people who have purchased these homes, put them on the internet, are renting rooms by the night. I don't see the great distinction between that and the Holiday Inn. But it is very clear in the ordinance, which people depend on when they invest in a single family residence. This is a personal property right. I buy a house in a neighborhood and I have an assurance from the city of Woodland Park that there will be no commercial operations in that. Your own grid is very, very telling. The grid work is empty. There is no possibility of a conditional permit or a permit by right in a residential zoning. Zoning is important, and we have thrown zoning out the window. We are allowing commercial enterprises, which instead of enforcing the ordinance and sanctioning these people, we not only provided them with business licenses, but we are also prioritizing them in the future should the ordinance be changed.
Your time is up.
So should shut them down. They're illegal.
Thank you, Mr. Paul. Next, I have Casey Kimball, excuse me.
Hi, my name's Cassie Kimbrell, and I live on 601 South Park in Woodland Park. And I am not an investor in short-term rentals, but we did purchase a home. And when you purchase a home, you have families, you want to know your neighbors. And we have times now that, breaking and entering, car theft is #1 in Colorado, and things that we need to consider. And so considering the fabric and the essence of our residential neighborhoods, I hope you guys take that in consideration. And I want to thank you guys for all the work you're doing, but we do have ordinance here. It is lodging, and we need to consider some of that stuff. So I do agree with some of Dave Paul and the person before me that were speaking. So I don't want to reiterate this stuff since you guys have already heard it. And so I'll speed it up and just tell you thank you.
Thank you. Next, I have Mindy Mead. Mindy?
It's Mindy.
Thank you.
And don't throw stones at me, but I'm here to represent STRs. And, it was said that crazy stuff is happening, and I appreciate you guys laying out the plan to help control that. People that have residences here that want to rent out a room are going to be, they have to come under the rules and regulations that you've established, which to me looks like you've addressed a lot of that. I would like to put my request in that you would consider the people who are actually living in their homes and they want to rent out a room for $50 a night or what have you, that they're actually in the house and with the lack of, sometimes it's hard to find a room. Can somebody rent out a space that they're actually living in, in their house? So they're monitoring parking, they're monitoring noise levels, they're monitoring craziness. And one of the most concerns of someone who wants to go into short-term rentals in their personal property is my house going to get destroyed? They're not, they're watching their property and they want to make sure the property is taken care of. I live by people that short-term rent their home, and that home is immaculate. They keep it very clean because they want to present a nice place. So I just think I'm standing in the place of those who want to hold on to property rights of what they can do with their own property. Thank you.
Could you give us your address, please?
Yes, I'm on Browning, 912 West Browning.
Thank you.
Mhm.
We have Deanne Betterman.
I'm Deanne Betterman and I live in Woodland Park. Most of the things I had to say have been repeated. The only thing I want to mention to you is that of our 8,000 residents, we have 1,500 who are considered seniors, and good neighbors and a good fabric of community is important to me. I've helped other neighbors. When I broke my leg last summer, I had people coming over right away. When we had 24 hours of snow, my neighbor went 3 times and snow blowed my yard. And that the only problem that might be kind of scary is not vetting any people who come in to our neighborhoods. I would like to give the rest of my time to Marie, if that would be possible. The rest of mine has been repeated already.
Marie, who? Very good.
There's 2 minutes remaining.
There are no provisions for vetting sex offenders, felons, or other undesirable people in the community. There is no provision for insurance coverage. I can see 10 drunk college students shooting off bottle rockets and burning down a whole neighborhood. The owner of the STR should be primarily responsible for paying all of the damages, and then the onus should be on them to pursue an out-of-state tenant or resident that caused the damage. The neighbors should not have that obligation. Also, the city has failed and refused to adequately inquire of the citizenry of the city of Woodland Park, and has only had contact with approximately 80 out of our 8,500 inhabitants. You guys set meetings up for 7:30 in the morning and 5:30. Most people in Woodland Park can't attend those meetings. The 80 people is not a statistically significant sample. Say that 5 times fast. And in fact, in science, it would be considered laughable. Thank you.
Next, we have Mac McVicker.
Good evening, Mr. Chair, members of the council, Director Schminke. My name is Mac McVicker. I live at 13719 Hetty Road. About 3 or 4 weeks ago, Aaron Vassilotti, the finance director, presented to city council an outline of 6 priorities going forward for 2023. Number 3 on that list was titled Housing and Zoning. It is the adoption of a housing strategy that emphasizes attainable housing, facilitating the development of workforce housing to boost the city's employment base. City Council adopted this. So I see any discussion about STRs as contradictory and maybe even hypocritical of what the city council has already adopted as a goal. Because you can't have workforce housing readily attainable to your janitors, your cashiers, stuff like that, your bus drivers, if some of those homes are being used for STRs. So I've got a question for the members of the planning commission to think about. Why not just stop it? You can, hundreds of cities in the United States have already banned STRs. And I know people get nervous about lawsuits. I'm 74 years old. I've been sued before. I cannot stop people from suing me. The only thing I can do is stop them from winning. And my record is 100% in my favor. So ask yourself that question. Why not just say, we'll make it real easy. We'll ban STRs. All these meetings go away. And nobody loses their money on a house because then they can turn it into a long-term rental or they could sell it. Even with interest rates going up, they're probably not going to lose money unless they bought it last week. So I know you don't have a dialogue at your meetings. I do at mine. For those of you that don't know, I'm chairman of the Board of Review in the building department. And Mr. Hartsfield has been to at least one of my meetings. And he's seen how I encourage dialogue. But I'd ask you, why don't you just say, ban them outright? No STRs, problem solved. Do you have any questions for me?
Thank you for your comments.
Hey, you're quite welcome. And you know what I'm going through now with Board of Review, so my empathies are for you and your team of what you're doing here.
Next is Linda Martin.
Linda Martin, I live in Woodland Park. One thing I didn't hear or see in the ordinance, the revised ordinance, is addressing areas that do have covenants. I've lived here for 20 years, or we've owned the property for 20 years in my family. And we were just able to dig up our covenants for our area. And it says right here in the covenants, only one single family residential building may be constructed on any residential lot. No single family residential lot shall be divided or subdivided into smaller lots. It goes on to section 2 that says that we will allow only single family residents. So I'm not understanding why your ordinance is overriding or appears to be overriding covenants. Doesn't make sense to me. I've lived here, like I said, we've owned the property for 20 years. In our area, we are aware of at least 3 different STRs. We have talked to not this law enforcement, but I'm retired from the El Paso County Sheriff's Office. I have talked to friends there. What is the best way to keep my neighborhood safe? And they all say, know who your neighbors are, know who's supposed to be in that home, and know the cars they drive. If we have people coming and going from different homes in our areas, homes that are not all paying the sales tax or whatever you guys are calling it, to have this business of short-term rental, I'm not going to know who's supposed to be in my neighborhood. 20 years, I don't want my neighborhood going to pot because our city council or our planning commission can't say no. It is your job and the job of my city council to keep me safe. You're allowing strangers into my neighborhoods. I need your help.
Thank you. Next, I have Matt Mc. I'm sorry, I can't read your last name. So Matt.
I think I actually. I'm good.
Okay. Very good. Last on our list is Paul McAllister.
So my name's Paul McAllister and I live in Olathe, Kansas, which is a suburb of Kansas City. And so our family has owned a cabin in Woodland Park for almost 90 years. And it had been our summer vacation. And so I wanted people to be able to experience Woodland Park like we did. And so that was why I began renting it out to people in short-term rentals. And from my perspective, I think it's good for Woodland Park because almost everyone that comes here comments on how much they like Woodland Park, how much they enjoy the city. And I agree with what Mindy said, that reviews are extremely important. And so I want to keep my property in good shape so that I get good reviews. And I also want to rent it to people that aren't going to destroy it because I want to be able to rent it to other people. And the short-term rental sites allow you to review the guests that are there. And so when I rent it to somebody, I can see what kind of reviews they've had from other places that they've rented. And I guess one other thing I think you should consider is, so our cabin is small, and if we didn't rent it as short-term rentals, it would just sit empty. And so it seems like it would be better to have people using it rather than just have an empty property. And also it's in an area where there's 3 cabins on the block and there's an empty lot at the end of the block, and across the street are other cabins. And so it's not really in the middle of a neighborhood. And so, and also our cabin, there's 3 cabins there that are known as Preacher's Row, and it's in the Woodland Park Historic Walking Tour. They're in there. So it seems like it would be bad to not allow people to be able to, rent something that's kind of historically significant to Woodland Park. And so I would encourage you to allow short-term rentals, but maybe think of what kind of context it's in and what kind of area it's in. And I also had thought a couple other comments that I had was perhaps the percentage numbers should be based on the number of bedrooms as opposed to the number of residences, because I think a lot of these short-term rentals are small. And so that way you would limit, it would just make it more how many people are going to be short-term renting, not just how many units. And also the 500-foot rule would be a problem for my neighbor. And so maybe perhaps you could have a limit of a certain number of bedrooms within 500 feet that are used for short-term rentals. So thank you for your time.
Thank you for your comments. That's the list I have in front of me. I would like to invite anyone else in the audience who's wishing to speak at this time to come forward.
Can I make a couple of corrections in your draft orders? You got typos.
Yeah, we'll be addressing those, I'm sure. Thank you.
I'm Tom Farrell again from 1175 Ptarmigan Drive, which is Stone Ridge Village.
You've had your comments.
Say again?
You've already had your time for comment.
Oh, there's no additional comment?
No, anybody else in this audience who has not spoken is welcome to come forward. David, do we have anybody online who wishing to speak?
We do. Mr. Zulaga would like to speak.
Very good. Mr. Zulaga?
Turn his mute off.
Turn your mute off. We can't hear you.
Can you hear me now?
Yes, thank you.
Thank you. Okay, Hi, guys. I have some considerations for you as you open this up for debate and discussion. First, I would suggest we need a map of what exists first and foremost before setting any regulations. Second, I think it's vitally important, particularly after all the comments we've heard today, to protect the quality of our community lifestyle. And the first one that comes up for me, that if we're looking to go down this road of regulation, is we need to protect the rental property for the residents, staff, students, and local workers. So I'm at a loss to understand why section 518.09.090 is included at all. Why are we considering MFS, MFU, and MHP? So I'd like that addressed at some point here. If we're looking at putting limitations on them, then I would suggest that we limit it to SR, UR, and PUD, something like 4%. I don't understand in the ordinance why ADUs are not being considered. Perhaps you could explain that to myself and others. I'm delighted to see the 500-foot addition in this. But my question would be, who is priority? Perhaps we could look at something like a lottery, or we could look at something like local owners first, then county, then tri-county, then state, then national. The 5.22.020, as far as the caps go, I like some of the comments I've heard here about caps, like number of people, number of bedrooms. I thought that was pretty interesting consideration of it. But the other thing too is this is all very speculative, and perhaps we could look at instituting something biannually to review this, to see if it's working or not working, to see what sort of influence it's going to have on the community, and not just set it in stone, but make it an obligation to review it in a couple of years. The 24/7 ruling in there, I think it should simply say something like that. Whilst they're operating the STR, the owner might decide they want to go on a vacation themselves, and they don't want to be available for 24/7, so they're not renting it for, you know, a month or whatever it is. And so it should be kind of reflective of that. The next point is the maximum number of occupants doesn't seem consistent with the long-term rental properties. I think the rule with the long-term rental properties is like 5 non-family members, but some of these STRs can have 15 or more people in them. So if you're going to impose a regulation in one part of the community, it needs to be consistent. I do agree with a lot of the comments of the fact that they are illegal already according to our ordinances and our codes. So we really have to look hard at the value of free enterprise and the value of entrepreneurship, but also balance it to where it is lawful in our city.
Zalaga,
I have 2 more points for you, and
your 3 minutes have expired.
Very good. Penalty considerations. And finally, I would suggest that the city and the attorney look at a draft and alternative ordinance option to disallow STRs except in commercial zones. So this has been one option, but I think it might be good to have council have 2 options to look at. Thank you for your time, and
thank you for your comments. David, any further Zoom participants that'd like to speak? Anyone out there wishing to speak, raise your hands.
If somebody would like to speak, time to be, I would appreciate it.
Nobody out there. Everybody else has had their option in house. So with that, last call. Public hearing portion of this meeting is now closed. Thank you. Appreciate all your comments. So now the opportunity for commission to make comment and discuss the options, how we would want to proceed. I know there's probably a number of small details, corrections, or punctuation or typos that we'll need to be addressing. But I'd like to give the commissioners option this time before we get into the minutia to make comments and statements. So Larry, you said you had some comments after public. You'd like to.
I have some changes or modifications to the ordinance itself, but I think at this time, what I'm hearing that there is concern being voiced tonight and not really mentioned previously before about the outright banning of short-term rentals. And we have been moving forward as a planning commission, as we worked with the city council to craft a regulation that would try to control or manage short-term rentals and not the outright ban. And I'm beginning to think that some of those comments may have merit. And the comments that I would make about the ordinance would probably not be appropriate at this time, but I do appreciate what I heard tonight. And I don't know if I'm going to be ready to vote on this particular action without further work session discussion.
Or a continuation of the public hearing.
Yes.
Okay.
Ms. Harvey, do you have any comments in general form?
In general form, well, yes, first, thanks to everyone who's provided input tonight. Yes, there was a process over the course of the year to solicit input from stakeholders. There was an online survey that ran for a month with, I think, around 340 responses. So that was a substantial number of folks that provided input both for and against short-term rentals with everything in between. And I appreciated that. And there were, as mentioned before, 2 town halls, I guess is how we would characterize them. And I attended both of those. And there were representatives from both sides of the issue. And I listened pretty carefully to that as well. And what ultimately came together through the staff was a summary or an analysis of the input they did receive, which also included individual interviews with stakeholders from hotel, motel owners to STR owners to those that did not favor STRs in our community. So those things were considered, but still this public hearing is just as important as any of those events that occurred. There were a couple of things that were brought up that I would like to get clarification from our attorney who's online. Mrs. Martin brought up a very important point, and Mr. Penland's brought this up before. This ordinance versus covenants and HOA. Nina, can you explain why covenants and HOAs actually trump an ordinance regulating STRs?
Yes, I'm glad you brought that up to clarify. So a covenant restriction is recorded onto someone's property. So they could certainly be more restrictive than the city code. So it's kind of the opposite of what was presented. The city code has regulations, and then HOAs can certainly place and record covenants and restrictions that are more restrictive. So for example, in this case, let's say you all allowed short-term rentals everywhere, a covenant that prohibits it, that is recorded on the property, and that governs what the use of that property is. And it could be more restrictive than city code.
And is it appropriate to include wording in this draft ordinance that addresses that situation, or is it simply?
No, that's just
Part of the
general,
law.
basic real estate law in the country. And I don't want to put the onus on the city, you know, even to say that the city shouldn't accept any applications from, you know, where covenants and restrictions prohibit them. That puts the onus on the city. You know, people need to speak with their HOA boards and that kind of thing. So Karen did have a good idea about putting on the application materials or license material is like kind of like a warning, like, you know, make sure you check with your covenants and restrictions. That's appropriate. But other than that, I would want to have our code, you know, say things even just to clarify, because, you know, to clarify one part of the law, we don't clarify every part of, you know, general real estate law. So.
Thanks, Nina. For now, that's the comment or query I had of our attorney.
Well, and I would, Nina, if you could add one particular piece, and that would be who is responsible for enforcing the HOA covenants? If you could clarify that.
Oh, well, it depends. Usually it's the board of an HOA. I mean, it depends on how they're written, but it's certainly not the city. The city should not and can and definitely will not, if I'm the city attorney, enforce private property, you know, things that are recorded onto private properties or that's for the HOA to do. Usually for covenants and restrictions, it's never for the city to enforce those things.
And for the record, I have no known conflicts of interest with this particular ordinance or the issue itself. My husband and I live by ourselves. We have no in-laws or outlaws in the city, and aside from our 2 dogs, I have no conflicts of interest.
Mr. Brown, any comments at this time?
Okay, sure. Thank you, people, for your comments today. I am actually sympathetic to the views many of you expressed. I'm not comfortable with the lodging business going on in our residential communities. At a minimum, I would like to see any ordinance the city addresses do what was asked here, is at least stop the invasion and limit it to where it is now. I'm not certain that the support would be there to try and immediately do a whole lot more to reduce that. At a minimum, stop it where it is now, build in provisions that will assure that it is well regulated while it's going on, and build features into that over time would increase the more desirable sorts of this activity. And by that, I refer in particular to owner occupants. Whenever there's a choice to have between a corporate entity renting out a property compared to a homeowner renting out on an STR basis when he's off for 6 months in Florida or wherever, I would much rather have it be the owner operator do it. And so there's preferences we can give that would, over time, as property ownership changes, that limited licenses would tend to move more and more to the owner operators of these places. There is, I think, in some previous discussions between the city council and planning commission, is already recognized. I think there's a lot of support for a special type of owner operator, that being one who lives in the house all year round, but rents out 1 or 2 rooms to someone to help supplement his income. And that, I think, the intent is, unless something changes, it's not drafted in the ordinance now, we've been asked for it and it hasn't happened yet, but is to basically unregulate that sort of thing, because it appears something reasonable to do and desirable for our neighborhoods. So anyway, that say I'm sympathetic to your views. I would like to restrict these things, and I'm acting in a way that I intend to act in a way that I think will, promote these objectives that I'm talking about, and that can be constructive towards reaching a result, as opposed to a non-result now, which is what's really unsatisfactory now, the way it's going on now. And I'll beyond that one specific thing. One of the speakers asked about numbers rather than percentages. As of August 15th, I believe there were approximately 180 STRs in Woodland Park. Okay, and thank you all for being here tonight. Thanks.
Mr. Kennedy, you're still with us?
I am.
Any comments at this time?
Just the one that Larry pointed out, that the MFU and MFS percentages are reversed, and I think Nina's got that already.
Yes, sorry about that.
I think we addressed the covenants and HOAs. Is there a faster path for restricting STRs for neighbors and neighborhoods and creating their own HOA covenants to restrict them? Obviously, if this is a new thing that's come out over the last so many years, older neighborhoods wouldn't have addressed it potentially. But I know of a number of HOAs in Woodland Park that do restrict short-term rental of the property, and even long-term rental is restricted in some neighborhoods. So, for some of those people who want to take some steps, there may be some things outside of this ordinance that also allows you and your neighborhood to get additional protection from what you feel is a untenable situation. But at the same time, there are some short-term rental operators operating in Woodland Park, a lot of them in the commercial zone, which is fully authorized and not planned to be restricted by this ordinance. But I think there are some that are in residential zones where the properties are not suitable for long-term residences. They were built many, many years ago, as was mentioned tonight. So being aware of that, I think there needs to be some ordinance to cover this and address the concerns of the population of Woodland Park. But at the same time, there are some situations where properties are operating and not necessarily causing all the issues that were raised here tonight that maybe need to be considered. So anyway, and this is our effort to try and put forth a ordinance to go to the city council next. It's not necessarily a final. So that's what we're working on. Thank you.
Thank you. I do appreciate the attendance tonight and understand the concerns that have been voiced for the most part in opposition to the short-term rentals. And reviewing the existing ordinances, they're not authorized as commercial operations in residential zones. And I guess at this point, I'd like to put it on the table, to discuss the issue of, are we going to regulate them or should we be prohibiting them? I think there's a lot of arguments and efforts we've put into this effort to regulate them. And that has been our direction from council to create regulations to define that. So while I think I know what the direction this would go, I'd like to make a motion at this point that we recommend disapproving, not allowing short-term rentals in any residential or multifamily zoning districts. So that is a motion I'd like to put on the table.
Okay, could you restate it, please?
I move that we recommend to council that they prohibit short-term rentals in residential and multifamily zone districts. So if I have any support, I'd entertain a second.
Yes, I think it'd be useful to have some discussion to understand that. The example that was given. Of the-
Two points. It's partly procedural. From a staff perspective, it would be helpful if the zone districts were named. And then second of all, I believe procedurally, somebody should second the motion and then you can have discussion. So Nina just nodded yes, so I'm on point with the procedure there.
Very good.
So
And I will clarify, is it at the list of
the zone districts you would
zone
like to prohibit.
districts?
Thank you.
So I would like to prohibit short-term rentals or recommend prohibiting short-term rentals in the suburban residential, urban residential, multifamily, suburban, multifamily, urban, and multifamily HP.
Mobile home park.
Well, mobile home park, excuse me.
PUDs are a mixed zone.
How about commercial areas of non-commercial areas of PUDs? You have to figure out how you say what you mean there.
By the way, I left that off the list.
So you're also recommending that they not be allowed in mobile home parks?
So the SR, UR, MFS, MFU, and MHP, mobile home parks. You had two points.
Well, I guess the other outlier is residential PUDs, and then you need a second on the motion to do discussion.
Yes, I would like to include residential PUDs.
Any seconds on the motion?
All right.
To
You can help
discuss.
advise
then.
it, no, help advise us as to the rules here too. As stated, I wouldn't second it, but perhaps with some slight modification that we propose differently. Somebody else may feel differently.
I would entertain modifications.
Can we have?
After a second, yeah. And you could second and not vote for something, but second to start the process and then you make an amendment. That's what I would say, unless the person who made the motion withdraws and amends it.
I would second the motion. If it were modified to provide for owner occupied residences.
So I guess we need a straight second, and then we can entertain modifications. Correct, Nina?
Unless you, yes, because then the other
Just
person can
withdraw.
make that motion if it fails.
Yeah, so to restate, yeah, a motion second. Somebody could then move to amend the motion on the table, or you discuss and vote on the motion on the table, and then somebody else proposes a different motion. Because, the motion as stated could potentially.
Second and amendment combined. Is that-
Or if a motion isn't second, it dies and then a new motion can be made, either or.
Apparently you have to withdraw your motion unless someone wants to second it as is.
It's kind of dying for lack of a second.
For lack of a second, I will withdraw my motion as stated. Thank you. So
Are we back to discussion?
All right.
There's not a motion.
Any
Oh,
other
you could
discussion?
discuss or make a motion.
I will try a different motion and perhaps someone will second it.
Can we have a little discussion first?
Hang on a second. Just to make sure Nina's up to speed, Chairman Hartsfield withdrew his motion.
Thank you.
You're welcome.
Yes.
Chairman Hartsfield, can we have a brief discussion?
Certainly.
I'm in favor of incremental steps here. This ordinance draft that we're sending to the city council provides significant restrictions on short-term rentals that don't exist today. It does cap short-term rentals at nearly the exact number that we have today. Doesn't mean that it will live in infamy forever. It could be modified and adjusted as we go, but it's a first step. I would think taking the step to completely restrict short-term rentals from existing in Woodland Park in all the areas except commercial zones would be significantly impactful to a number of property owners, and the considerations need to be made as to whether or not the ordinance as drafted by council based on numbers of ordinances in many cities and areas that are in our area and others doesn't work before we abandon it. She did a lot of work. Our efforts were to create an ordinance that addressed a number of issues that were raised by a large group of citizens that were polled. And I think the steps to completely eliminate it needs to be considered in a broader context than just this one meeting. So that's my discussion point. I would be more in favor of continuing with the ordinance effort to take this incremental step and then continually further evolve it as we see how this impacts the business of short-term rentals, the residential communities. And I think there are potentially other avenues for communities that are having significant problems, but the pieces that we put in the ordinance that will allow us to pull licenses from short-term rentals that are creating problems for neighbors and others, that will have some impact that will be favorable to neighborhoods. So that's just my discussion topics.
Thank you.
Mr. Chairman, if I could then recommend that a motion be made to approve the draft. And then as discussion progresses, if in fact we get a second on that motion, that we can offer amendments to this draft. But I appreciate that we had to put that on the table to begin with. Okay, all right, or we just all go home and say, no more short-term rentals. That failed. So now it's time to look at this draft and see if it in fact does fit our community. And if not, then we'll amend it. So my motion is to approve an ordinance of the City Council for the City of Woodland Park, Colorado, amending Titles 5 and 18 of the Woodland Park Municipal Code concerning business regulations and zoning to license and regulate short-term rentals.
I'll second it.
Excuse me. No comment from public at this point. Thank you. We have a motion looking for a second.
I'll second it.
Motion and a second. This is time for some discussion.
Well, we have to decide if we're gonna, no, I guess we can do discussion. I'm sorry.
Yeah, I just want to clarify what the motion entails. If we can.
It was straightforward. Approve an ordinance as I stated.
An ordinance or this ordinance?
This ordinance. Well, the way it's stated in the draft is an ordinance. There is no ordinance number yet.
With no further modifications. Is that correct?
I did not say that. I just simply said to approve. And then as discussion and a vote occurs, then we may modify it.
Larry, everyone's had some thoughts. Do you have some comments?
I'm a little confused on the order we're doing this. I'd rather take the time to discuss and vet some of these issues we heard.
You have to do that with a motion on the table.
You have to do it with a motion.
I don't know. Nina, am I wrong?
There's two ways to do it. One way is the way you're doing it, and another way is to discuss and then make a motion. And I'm going to help you discuss procedurally to make the right, like the motion that I'm hearing you say to help you guys, but with the amendment, so you can make it either do it the way you're doing right now, or approve the draft ordinance with the following amendments. And then after you've discussed, maybe you'll have a few, and then that will be what's presented to the City Council.
I think our usual practice is much more along the lines of discussing the matter, only making a motion on a draft when it's.
Okay, if you want to do it that way, I'll withdraw.
When it's clean.
Ken, I'm going to withdraw my motion, but the bottom line is we're going to discuss this ordinance and amendments will come as we discuss the ordinance, and then we'll make a motion. Unless we continue.
Okay.
So you.
So the motion has been.
Yeah, and you got to ask Ken to withdraw a second.
That's fine.
Okay.
I withdraw.
Okay. So.
Back to the ordinance.
The draft, back to the draft, and that was anticipated that we move forward with this ordinance, but I wanted to make sure we have the opportunity to address the concerns the public has issued tonight, and that decision's been made basically to move forward with some ordinance by not recommending denial of short-term rentals. So I think there's a lot of items. It's a good start on this document, for the direction it's heading. but I think there are a lot of comments and detail that need to be addressed. So I'd like to proceed with that discussion and see what modifications may be entertained if as necessary from the commission. We'd like to start.
I'm going to suggest you start by going back to the list of where you think they ought to be, and then let's just discuss that. You said not in.
Well, my discussion or my proposal motion was to restrict short-term rentals in residential districts and in multifamily. Residential, but trying to preserve the existing nature of the residential districts was the reason for that. And regardless of withdrawing that motion, the multifamily, I think part of the intent is to maintain housing for workforce, if that's the appropriate term. Affordable may not be the proper term, but multifamily has a tendency to be in the more affordable and available market. So that's why I was, regardless of this, and moving forward, I would like to see those multifamily zones and the mobile home parks eliminated from the available short-term rental areas.
That's going to jump us to the second page of the draft. Do you want to wait until we get to that section in case there are any other issues in the definitions and licensing limitations and requirements? Because I think that's, I mean, and that is a valid discussion, but do we need to cover anything before we get to that?
Okay, rather than so you're proposing that we go through the ordinance part by part as we have in the
Yeah.
past and make sure we're consistent with the direction we want to
I
head.
think so.
That said, that's a big enough issue. If to adopt what you just said, seems to me is going to affect everything else in this document.
You want to go to that first then?
Excuse me, Mr. Chair.
Yes.
To facilitate the discussion of zone districts, it may be easier to look at page 6 in the use table that would land within the zoning chapter of the regulations. And then from there, any adjustments to caps by zone or that kind of thing could be modified, but this may be the easier mechanism to look at for
Yes.
the zone district conversation.
Appreciate the suggestions. So looking at
I'd like to make a comment before you move on, Ken. The multifamily urban and multifamily suburban zones include townhomes that people buy for vacation homes and such that I've heard mentioned. And there's 11 current units in the city. So they're already capped. When we put this ordinance in place, there won't be any more other than that 11. I don't know that it warrants a lot of attention at this point to try and say we're going to say none when we're at 11 right now. I think the fact that we're putting the ordinance in place and there won't be any more unless they grow in quantity and get approved by either a change in the percentage or something in this ordinance. It just seems like a lot of work for 11 short-term rentals out of the 188 that are licensed in the Woodland Park area. I think our focus would be more on the other residential zones if you wanted to do something. And we've also capped those, except for the urban, there would be room with the percentage that we set for a couple more. So again, I think incremental steps is what I would recommend rather than trying to, well, anyway, until we know how those short-term rentals are operating and what their impact is on their neighbors, I think just stopping is what the ordinance is attempting to do, is to put a cap and then see where we go from there is potentially the future. But anyway, that's just my comment. I just want to point out that there's 11 in the multifamily zones.
Ken, was your intent to prohibit short-term rentals in apartment buildings like Trail Ridge? We had that discussion over the summer and at the last work session. And
I still don't understand that one. It seems like apartment complexes already restrict that sort of thing. in
Right,
their lease
exactly.
agreements.
And
So
I don't know if that's what you were thinking of, prohibiting short-term rentals in apartment buildings by condominiums and townhouses. I don't know.
No, well, I was just pointing out that the townhomes and the duplexes are typically, I think, what's going to be in those multifamily urban and suburbans going forward for the most part. There are some apartment complexes, but they already restricted in their lease agreements most of the time that you can't re-rent your apartment out. But maybe not.
Response to you, Carol, yes, I think apartment.
Mhm.
by
And they would
multifamily.
be ineligible to apply for a license because they wouldn't have, they wouldn't be the owner under our definition of owner. I mean, an individual leasing an apartment couldn't sublet it under our definition.
You can't do a short-term rental on a property you don't own.
Apartment
That's
owner
true.
could.
In our the current draft of the ordinance, it says they're prohibited in apartment buildings. So that's separate and apart from the zone district discussion.
Okay.
Nina, could I ask for your comment on from legal issues, liabilities, or potential concerns involved in when first establishing caps? If we put cap, if we attempted to reduce those numbers later, does that create some difficulties as opposed to when you first creating the, if you expand it seems like that's reasonably risk-free. But if you create it at 4 and then try to reduce it to 3.5, you're going to have 0.5% of people got stuck are going to be coming in with claims. What sort of, is that correct? What other?
Oh, at first I thought you're going, it's always good to be more restrictive than less, and then you can get less restrictive as you go on. You have the ability, I believe, to, in especially non-commercial areas or these commercial lodging, you have it's a business license that was given that was only for a year. So we have the right, there's no established zoning rights. That's being said, it's probably practical if you're going to do a cap to, not to do it just 5% under, maybe just have it the same amount. I'm not going to speak to whether, I don't think that people would have a legal claim, but I would never admit to that like this, that someone's going to have a claim if they do that. That's not in the interest of the city for me to say, but business licenses were given for a year. I do agree with what you're saying, that if you're going to cap it at 3.5 and there's actually 4%, if I were the policy decision makers, I would probably go up that 0.5% just to keep it as is and not move forward. That being said, it's a policy decision.
What about revisiting the cap, not necessarily per zoning district, but total cap? We talked about that a long time ago.
Yeah, it was in the last work session, we would put the cap by zoning district.
Yeah, but back it up and just say there's a total cap, so many short-term rentals, regardless of what zoning it is.
Getting some feedback.
Are you guys talking, are you Ken or?
Well, I'm just hearing some feedback from the microphones or something, so. I guess if you have a comment, Nina, on the maximum versus the zoning district.
No, that's a policy decision for you all. Make it.
Thanks.
Most places have just a general cap, but I understand what you're trying to do with, each district. So, either are defensible.
If we're having the caps, I prefer to have them by zoning district. We have them overall, creating potential that one place goes in another district might be burdened in ways that we can't anticipate.
And now Ken can explain his rationale when he came up with the percentages by zone, but my understanding was currently there are less in some zones than there are in others, and the most short-term rentals that we have right now in the city limits are in commercial zone, and we're not proposing caps for commercial zone. Just trying to create a restriction that will limit in urban and primarily suburban residential, correct?
Well, maybe then the best thing to do is just keep them by the zone districts. at this point. And, go from there.
I want to make sure, though, that the original concern that Ken had was that should, from the use table, the permitted use table, are there any that we want to eliminate at this time? Like mobile home park.
Yeah, as a mobile home park, I don't think we have any information on amounts that are there currently. Mobile home parks also appear to be an area where there tends to be little space between units. Parking, cars parking tends to be a problem. Use around here is often with outdoor activities, barbecue and things like that. And it tends to be right into your neighbor's area and such. Mobile home parks would strike me as tending not to be.
Are there any property owners that own the land and have a title to a mobile home site in Woodland Park? Aren't they all rented spaces? So there wouldn't be a license given to anybody in a mobile home park if they're renting the space.
But right now, somebody in the room has like dialed into Zoom or something. I don't know if that's where we're partly getting the feedback from. So if you could check your phones and connections, that would be helpful. So sorry for that. If my memory is correct, and it may not be, I don't believe there were any STRs within the existing mobile home parks in Woodland Park.
There are none in the table, that's correct.
And then there is a little bit of a conflict right now, since there are two other places in the ordinance where it specifically says mobile homes cannot be used for an STR.
Exactly.
So logically, it really would make sense that they're not permitted all in the mobile home park zone. To answer your question, Commissioner Kennedy, there are instances where the owner of the park does own the unit in a particular space and, rents that unit.
Gotcha.
As a long-term rental. But I'm not aware of somebody in a mobile home park that owns their unit, owning the land under it.
But we've already addressed that in one section of the ordinance where we say mobile homes are not eligible for short-term rental. So we really should eliminate that from the
We should
usage.
delete mobile home park 2% and add it to the bottom of the section. The last sentence prohibited zones, MHP.
I'm
Which
fine with that.
section are you in, or can we focus on the table first?
522.020G, which sets forth the caps. So remove 2, 4, 6 lines down and MHP 2%. And in the last line, add after AG, MHP.
And on the table, we would eliminate.
And on the table,
Eliminate that and make it a blank.
Correct.
I have a question. How do we, I wasn't around when the discussion was held on tiny homes. Where do they fit in this? And do we have a specific definition of tiny homes that we should add to either permitted or prohibited?
I don't know about the second part. The first part, the existing village that's under construction. In that situation, it is a straight zoning district. I forget which of the multifamily zones it is. And there's no, requirement for, square footage of a dwelling unit in Woodland Park. So that's a situation within that straight multifamily zone district that somebody owns the unit, but not the piece of ground.
That would prohibit them from applying for a license under this draft.
I don't know that it does.
Then should we include it? I don't know. I'm just suggesting
Yeah.
that. I don't know. Does a tiny home have a VIN number? Because we've kind of looked at it from the.
So those particular
modular
units by the
houses.
They're
golf
modular,
course
yeah.
are permanent foundations of pre-manufactured homes.
They were looked at as being single-family residents.
They're small in scale, but they're
Yeah.
single family.
If our intent is to limit the number of STRs within the community, should we add tiny homes or whatever our legal definition of a tiny home is?
in fact defined as tiny homes by
No,
the
they're
building code.
They're just defined as
Small,
single.
single-family homes.
And what is that zone over there called? Urban residential? Or commercial?
It's.
It's
hang on.
multifamily something.
I can tell you in a minute. Let me go back to my zoning map. I had it up a minute ago.
I think that that was probably part of the intent of establishing that village was to rent some of them out as short-term rentals.
It's multifamily suburban.
Yeah.
Yeah, it's multi.
So the property owner could own individual units and
And
then
then-
could lease them out on a short
But there
term.
would be none yet.
Where,
Not yet.
where,
There
where,
were- there may be
where's-
shortly, but there are none, that would be none yet.
Again, we're planning department or commission, so hopefully we're planning it forward.
would somebody tell me where in the ordinance actually has a listing of uses that are prohibited to be used by short-term? Oh, here it is. Okay.
Yeah, there's a whole laundry list there, but
Yeah. And-
I didn't, so our legal definition of a tiny home is simply a single family residence. It's,
No,
no,
short, single or tiny homes have certain provisions in the building code in a certain appendix Q or something like that, which I don't believe the city has adopted. Therefore, they're not allowed. They limit the square footage, but they do allow for steep stairs, sleeping lofts and that type of thing, which under a single family dwelling are not allowed. So by the building code. So I think these don't have those provisions, but I don't think there is a minimum size dictated in the building code as far as how large a house could be. You know, sleeping room needs to be 70 square feet, but beyond that, there's no defined dimensions in the building code for how small a house can be, unless there's something adopted by the city.
well, right now we have a limitation in our draft for multifamily. Would these be multifamily suburban or urban?
Suburban.
Suburban of 2%, no, 4%, I'm sorry. So is that a way to control tiny homes being used as
I
STRs?
think those percentages, Mr. Kennedy, were set based on the existing usage in those zones. Roughly,
They are, yeah.
you're muted. We can't hear you.
Sorry, all the multifamily zones are set at right at or just below the current usage, so there would not be any expansion of STRs under this ordinance in the multifamily zones.
Unless there's multifamily suburban, a whole bunch more are going to be.
Unless a number of units are added
Occupancy.
and the calculation is redone.
Shortly.
Yeah. It
I'd be
basically
glad
caps
if
it.
we're Setting a
Lower,
number, setting a number versus percentage.
In fact, it's zero now, but it will,
Well, it's
the percentage for the
4%.
zone is going to jump as these go online.
If you recall, the first draft that you looked at, if I remember right, Nina, the STRs were actually not allowed in the multifamily zone districts, period.
Correct.
So this was a shift that had happened from our work session.
because there were STRs,
Existing.
as Ken pointed out, there are 11 now within suburban and urban multifamily zones. So there's nothing stopping us from saying 0 for multifamily of any type.
Goes back to what the original
Mhm.
drafts.
And we wouldn't have to worry
included.
about, except on Thursdays under a full moon in Trail Ridge Apartments. I mean, simpler is better.
And this goes to our affordable housing effort. And it was,
Yeah.
Yeah.
it's the fact that there are some doesn't mean that there should be some.
Well,
I think the big
for
question is, do we want them in this type of development?
My-
Multifamily zoning.
no.
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 I agree, no.
Larry,
I agree with the Tory.
Ken?
There's several townhomes off Baldwin Street that we heard about that were bought by people for vacation and they want to rent them out when they're not there. That's the pre-existing, I believe. That was part of the discussion. Those exist in several residential areas. They exist in some urban residential areas. And so the question was, do we take the big cut now and not renew those licenses based on just deciding that they're not appropriate there today? Or do we just cap it and let the not licensed renewal process take its course? And if there are complaints and violations of the good neighbor policy and the other things in the ordinance that would cause it to not be renewed, it would not be renewed under that aspect of the ordinance, rather than us deciding that that's not an appropriate short-term rental today, just because it exists in a, I know the Baldwin Street townhomes are $500,000 each. And they're bought for vacation homes by several people. I don't know about the new ones we talked about on the planning commission that are going in, duplexes and townhomes in Stonebridge and some of those other areas. But hopefully, if people want those built and not to be used as short-term rentals, they need to put that in their HOA covenants and property covenants so that the buyer knows right out of the gate they're not to be STRs, and it's no longer a city-driven thing. So, Nina, do you have any additional comments? But that's where I was headed with it.
Well, just, it is a policy decision, whether you want certain homes to be for vacation for people or for workforce. So that's a policy decision. Of course, you could rely on the HOAs, but you also have the authority here to either regulate them or keep them as a cap, that's up to you.
Yeah, my thinking is that the vacation home is going to be their vacation home. If they rent it out and use it for income, or they don't rent it out, and it's not adding to the affordable housing, it's already bought by somebody who owns it. So is it of any value as a short-term rental? Does it bother the neighbors? If it bothers the neighbors, this ordinance will kick in through the complaint mechanisms and other things that says, you know what, we can't license that as a short-term rental. It's inappropriate for that neighborhood because the neighbors are complaining. Which I think that process starting will correct a lot of the problems. And then we don't, demand that, sorry, you're done without any due process or maybe hearing all these other people out. So I was taking the more measured approach, incremental step. But that's just my opinion. We're a group and we can all vote on it.
Karen, you had some comments?
I did want to add, I was reminded that the other piece that will come into play is the 500-foot radius. So in some of these areas that have a much greater density to start with, when you start putting those circles around the perimeters of the units or the properties, that will really help to distribute.
Oh, that 500-foot radius doesn't apply to any of the multifamily areas.
No, it's just for urban and suburban residential.
Then
It
it's,
could be.
Even urban, we said we're looking for planning. Planning
Yeah.
department was going to give some guidance on the separate distance.
so that would be a potential change to kind of address that if you were to, or another way to possibly try to tackle that.
That was
issue.
one of the examples where I thought when someone brought up the cap,
And it
it's
could-
useful to know where we're going to come out because it affects lots of other things.
Yeah. Anyway, that's just my comment. I'll listen to the rest of the commission and we can
So,
decide.
Just to clarify, the 500-foot radius does not apply.
As drafted, it says urban, suburban, and PUD. As
I mean,
our
that
agreement at the workshop is 500 feet urban and PUD, or suburban and PUD. The planning department will come forward with a recommendation that might be for a different number for urban.
urban, yeah,
I
instead of the
believe that's where the
500.
workshop left.
Yeah, I had started to mention that, and I realized that distance limitation was just for 3 different categories, and we were going to review whether it was an appropriate distance or not. But
Yeah, we had
if
talked about 250 feet on the urban at
Urban.
one point. I thought that was actually going to show up in the ordinance, but it didn't.
Yeah, I mean, we can add that tonight, but I mean, if you take into consideration the prioritization for the city of affordable housing, we'd be making a statement now to prohibit short-term rentals in multifamily in any zone. it sounds harsh, but it is a means of limiting short-term rentals without infringing on the property rights of homeowners. Single-family homeowners.
Just a point, Nina, I want to ask a question. How is a property owner who did some research, looked at our website for Woodland Park, and it says, if you apply for a business license and pay $35 annually, you can get a short-term rental license in Woodland Park. And so they build or buy a unit with the intent to do that. They go through the process, they get the license, and then we just, they don't have any recourse, right? If we just change the ordinance and they cry foul.
They were given a business license for a year. I think there's a stronger argument in the residential zones where it wasn't allowed that we have that authority. I can't say some of them will bring, lawsuits.
It's highly likely it'll become a long-term rental if that's the case, and they really need to get income off of it. So it does accomplish in some regard what Chairman Hartsfield mentioned, providing more affordable long-term housing. So it becomes a future retirement home instead of a vacation home, I guess.
I would suggest we have four people who are inclined to go with 0% for the multifamily zones. And we can take that and then see where that leaves us elsewhere.
So Ms. Harvey, Mr. Brown, myself, you as well, are agreeable to not recommending them in multifamily zones. Is that correct?
Yes.
Four of us in presence, and Mr. Kennedy, I think you have a separate opinion on that.
That would mean removing MFS and MFU from line 6 of paragraph G and adding it to the last line, paragraph G, where we just moved MHP a few minutes ago.
And modifying the table.
And modifying the table in the zoning section.
That will not result in me changing any decision on forwarding this draft. Positive or negative, I have no issue with joining the group and moving forward with that language change.
Thank you, Ken. We've been kind of jumping around through this, and I know Ms. Harvey's proposed that we kind of start at the front and go through and address those items.
Novel idea.
Yeah, but I think it's still helpful just to do where we are now, because there's various places these decisions will come up and some correction adjustments to make.
With
that, starting in the definitions, line 22010. All right. I think it was discussed in the last work session, and I think there was pretty broad agreement that simply failing to expressly say that a short-term rental unit, by writing to say short-term rental unit means a dwelling that is renter utilized, et cetera, having not providing for a portion of it does not deal with the exemption for owner occupiers who are present during the rental as an exclusion from that. I think we all discussed that needed to be made explicit. A couple of reasons. First off, renting partial unit does not make it an owner occupied rented to a partial unit unless you say it's the resident, the one who's there. I had some language which I wrote up. I'm sorry, Ken, I didn't know you weren't going to be with us tonight. But I had some language which, Nina, if you would, I'll give this. If you draft it, that's fine. I'll use yours, but we weren't getting anything. I would recommend that at the end of the short-term rental unit definition, which reads, short-term rental unit means a dwelling unit that is rented or utilized for furnishing, lodging, accommodation, and occupancy for periods of less than 30 consecutive days. I would add text that reads, however, a dwelling unit shall not be subject to this chapter when the only rental or utilization of the dwelling unit for furnishing lodging accommodation for periods of less than 30 consecutive days uses only a portion of the dwelling unit and occurs but while a person who owns directly or indirectly through an entity or trust at least a 50% fee simple interest in the dwelling unit actually occupies a dwelling unit as that person's primary residence during the same periods as that rental or utilization of the dwelling unit. It's a lot of words, but I played with it a bunch of times to get all the different elements we're talking about. So we're saying that if somebody is in their principal dwelling unit that is their principal residence, if they rent out a part of the building, but not the whole building, and they are generally occupying that premise during the time of that, we're not going to treat that as a dwelling, as a short-term rental that's subject to this chapter. Now, I got it wrong, Nina. I don't-
If maybe in the motion language, we could just say conforming language by the city attorney, because most of that I would be okay with, but when and I'm sorry I missed that one, that in this ordinance, but my draft, but some of the part where like it's intended that they're the primary resident, they're the primary resident, not the trust thing, that thing. And then I'm probably going to then define primary residence very.
Okay, well, that, I had some questions about when the reference trust, and we'll get to that. We'll get to that later. This.
From a staff perspective, I'm always very concerned when something that's really a standard shows up in a definition. So I appreciate where you're wanting to go with this, but I don't think the definition is the appropriate place.
And
The
a
other-
part I could go various ways. Definition where it seemed to be was discussed at the workshops. I was trying to get wording to cover that.
The other issue is it really goes back to the length of time that the rental happens. That is a key element because we go back to the lodging tax piece that's already on the ordinances that say if you're renting a room for less than 30 days, you have to pay and collect and pay the lodging tax.
The lodging tax still applies here unless you're gonna, I'm not proposing to go that can do that. This was the intent to keep the government, the government's eyes off of, do you have insurance in your property and whatever.
And this discussion came up in the joint planning session or work session that we had with city council, and Councilman Zuluaga brought it up, is I'm renting my bedroom out while I'm living in that residence. And I thought the general agreement was then we don't want to get in that business. But I know that you're now asking, well, until the moratorium went in place, is that people who were renting out a room in that kind of a scenario did have to have a business license.
And I would suggest it's the time period. That's really the key element. When you're renting that room for less than that 30 days, that's where I think you see all these other ancillary impacts that people have been concerned about with short-term rentals. When you're hitting that 30-day window or longer, that's a roommate.
Yeah, well, that's right. Did you notice I just said it's only for rentals of periods of 30 consecutive days or less?
Yeah. Well, which, yeah.
I may have said it right. It's complicated to write this.
Yeah, no.
Can I just make a comment? If a majority of you agree to that amendment, I could recommend just a general amendment language that I will draft to kind of make sure we address everything that you're saying. I apologize. I can't believe I missed that in the last draft, but I think it would be proper to make, when you make your motion, just to, if a majority of you agree, that would be one of the amendments.
Let me add further as part of the same idea. What this generates is the need for a definition of primary residence.
Yes.
You've asked for it repeatedly. We haven't gotten one. I've on this sheet I've got here, I have a sample of one. I didn't.
Oh, no, I have something I would recommend if you guys are gonna go that route. It was more in the primary residence route, that whether you're going a certain way, but if the general idea that you're saying, if you have a majority of people, we can talk about that maybe it's in to Karen's point, it's in a one of the sections, like the beginning section, that this section shall not apply to somewhere where it's primary residence, owner occupied, everything you're saying, but just.
Remember, it's all the condition we described. I'm trying to explain because we covered this a week ago or 2 weeks ago, and nothing appeared. It's an owner occupier renting out a portion of a premises where the owner is the principal residence and is actually occupying the premises during the period of those short-term rentals going on.
Yes, and I apologize. That's one thing I missed.
I missed the definition of primary residence, and we further, I think it's going to be necessary elsewhere to generate further a definition of owner occupied. Owner occupied short-term rental unit is a short-term rental unit. There's a primary residence of a person who directly or indirectly owns 50% or more fee simple interest. But we're gonna need an owner occupied definition, because I believe we're gonna talk about it elsewhere in the document.
I agree with the primary residence, and then it could just be the standard that the person is there when it's being rented out. I highly recommend to draft, we'll define
Okay,
primary
you're
residence.
expressly saying you're not agreeing to, right? When we generate a use, an application during the document refers to owner occupied short-term rental unit. Can you agree we can have a definition for it when we get there?
That it should be primary residence and then that they occupy it during the rental, because it's very much easier to establish primary residence by the things that I have in other ordinances where it's where you file your taxes, where you vote, that sort of thing. And then it's just the requirement that they need to be there.
That wasn't my question. I'm saying, can we, if we come up with an application for the term owner occupied short-term rental unit, can we have a definition of that term?
I'm just recommending that if you do that, you define it as primary residence. And because that's much more easier to define. And then in the standards, it says that, to your point, it's exactly what you're saying.
Okay,
It's
so
just
the
I would
answer is
draft it a
no.
slightly
I get
different way.
Thank you.
I'm recommending that if you guys, as a majority of you, for this standard, which is everything you're saying, it's just I would write it just a slightly different way and also define primary residence, then we'll make that amendment and I'll put that into the ordinance.
All right, and to assist you, I trust Karen, I have several other pages, you'll be able to fax this material
Oh, yeah.
to Nina.
Absolutely.
Tomorrow, or whatever.
Facts.
Well, what else?
Scan will be better.
Scan, whatever.
So
Yeah,
however.
but
this-
just, I'm agreeing with you, just
incorporated,
slightly different language, so you don't get, and yeah, we're saying the
The
same. thing.
intent, I support. The wording, we'll let council figure that out. But as long as this intent is included.
Anyway, those are these concepts I thought were needed to be addressed in definitions or elsewhere.
And any other definition corrections or comments? That was 5.22.010.
All right.
You have something?
All right.
Lee?
They have something else too, and this is responding to a comment that was made in a letter to our group last week from Ms. Skinner.
Tricia, yeah.
And I'm not sure of the breadth of the impact she suggested is right, but I agree with the general tension. I don't see any reason that a short-term rental unit needs to mean a residential dwelling unit. We can delete the word residential, say dwelling unit. Dwelling unit is defined in our zoning, in our zoning ordinance already. And the word residential, dwelling or residence means a building or structure used in whole or in part for human habitation. So it doesn't create the inference that we're somehow saying
There's
that
some
short-term
residence.
rental is residential. So the use of the term residential can be deleted, I believe, from the line, the first line of the short-term rental unit definition.
Mhm.
In 522.020 G, in the third line from the top and the fourth line from the bottom. And the definition of short-term rental unit in the new section 1806.481. I don't think it hurts anything. I think the word is just added as surplusage anyways.
Concur.
And also try and make sure everyone understands that we all do read all this stuff we get from people's suggestions.
She'll appreciate that.
Anything else on definitions? Look at licensing limitation requirements, 5.22.020.
Under G, we already talked about the elimination of the multifamily suburban, multifamily urban, and the mobile home district.
Which section are we on now? Which paragraph?
G.
On the established cap. So the caps that we're discussing are only suburban residential and urban residential and PUD.
Yes.
Larry jumped ahead of me a little bit. I had some question about F. I'm not sure it really works as written, and I'm not sure we understand the purpose. All right. I would think the purpose is, Nina can comment on this, is simply to assure that the person who is the applicant is a proper person to be representing the property. In essence, taking a position on the property with the city, should it have this permit or not have this permit. If that, assuming that's the objective, it says the name of the short-term rental business license applicant must match either the name of the owner of the deed on the deed for the property. That's straightforward enough, a human being. The name beneficiary of the trust owning the property. Well, I guess named, was intended. Beneficiary of a trust can't act for a trust. A beneficiary doesn't have any role. I mean, we know who will act. It's the trustee who acts, not the beneficiary. Beneficiary usually has no authority to act. Now, they may be the same person if it's a revocable trust for the property, but it's the trustee is acting, not the beneficiary. And the last one, the name of the person controlling the corporate ownership of the property. That one, the question was, why is it corporate ownership as opposed to business entity ownership, a broader one? Well, LLCs, in fact, are probably more common than corporations for owning is. Could be people still using limited partnerships, and there are other possibilities.
That would still be a corporate ownership. That's how I would define that. The trustee, I'll look into that. I think I made that. I thought that was the amendment you had shared, but
I'm sorry, could you?
You're a little mumbled, Nina.
Yeah, I can't hear.
Oh, so the corporate ownership property, that's a generic term that is applies to any type of to your point, an LLC, an LLP. The trust, the name beneficiary, I thought that was a conforming amendment that you had recommended, but I'll look into I think it might be both a named beneficiary and a trustee, because there's been situations where, well, I'll look into that, how it should be defined. So to amend that for the trustee.
The discussion came up when we had the joint planning or work session with the city council, and one of the realtors brought it up. I can't understand why a named beneficiary would be able to do that. I would think it would only
you're right.
be trustee.
Yeah, you're right. That's why, yeah. So amend that.
Finally, the applicant must possess at least 50% fee simple ownership interest in the property.
Yes.
Right. In order to count somebody as it makes sense to count them as, for other purposes, the owner operator or the owner occupied I was talking about, which we haven't defined yet, may make sense. And I think it does make sense to be a substantial owner, the 50% owners to be the owner occupier. Why does an applicant, if we're going to allow business interest trusts and others do, why does the applicant have to have a 50% fee simple ownership in the property?
There's many, that's to prohibit, there's a lot of these things, the CASA, where the person owns like a very small part. This is to address concerns that were brought up, consistently. If there's 4 people who actually are members of the LLC that own the property, it's just a majority,
then it's not one. Isn't the point of all of this? We want to make certain that the person who is signing, if it's not a natural person, if it's a trust, it's the trustee, and if it is a business entity, which, corporate or otherwise, that it be an authorized person to act for the entity.
There's been situations in other municipalities of mine that have come up only in the past few months where when you look behind, it's important that, especially if you're going to start talking about residency and that kind of thing, that that the person owns a significant portion of behind that corporate ownership. It's just a way to preserve and protect the intention of, if you're going to go with these regulations and maintain community character and kind of reduce these type of things. It's just one way that we've utilized that.
Is it possible for 3 brothers owning the property as tenants, as owners in common? Is it possible for them to apply? Because there's no applicant, there's 3 applicants.
It's- Together, yeah, of course, that would be 50, more, at least 30%.
Well, think about it. It seems to me it's not necessary, but okay.
I think part of that came up because there was a discussion of the Marriott was buying up small properties or small residences and then getting into the STR business.
Yeah.
I found that it has been necessary, at least
For
3.
the owner, that should be sufficient, right? What do we-
I have found that it has been necessary in at least 3 times I could think of in another city within the last few months. So it's just try to protect and preserve everything that you're trying to do here. So
Well, I agree with Lee, though, that it's somewhat confusing if you say 50% fee simple ownership when you might have joint tenants. So
right. So
is that even necessary? If you simply say that individual who's authorized to act on behalf of that property or that corporation.
and owner and one of the, okay, yeah, I understand what you're saying. We'll tweak that language. I don't think it necessarily warrants part of one of your amendments, because I feel like it's just to clarify, just to not confuse things, but I'm making that note. As well as the trustee amendment.
All right, back to paragraph G. The last sentence, you've cleaned up some of them, they still exist here. Short-term rentals are prohibited. There's no, we don't have short-term rentals, we have short-term rental units.
Mhm.
I thought I cleaned them all up, but let's see. I mean, I'll look at that.
I think there's also in
I see.
in G and in A, it's a N and H.
Okay, I'll make that, again, I don't think it's part of your amendment.
I've got several more. It's easier if you would just do a search of those and correct them.
Yeah, I did that before. I just missed some. It's fine, but I don't think I'll just clean it up before council. I don't think it needs to be part of your amendments. It's not substantive, but I'll make that change.
And I have more on H if people want to do that, or somebody else can jump into something else.
Anything else in these items? Yep. On G, the next third of the last line says licenses Hall B, just a missing S typo.
Oh, yeah, I had that else. Good job.
Can you say it again?
Third of the last line on section G, it should be licenses shall be.
Oh, yeah.
Licensees, okay. Simple typo.
And again in G, on 1, 2, 3, 4, 5, line 6, short-term rental unit inventory is a running tally of the
Thank you.
number
Thank you.
and of.
So.
Beat up G pretty good.
Marked up. You have something else down the list here?
On one at H.
H.
Okay, a couple of, right, one just for clarification. This paragraph was written before the change was made to G, which referred to, had multiple zones when it was only a single zone. So to address, it's just a minor one. In the event the maximum number of licensed short-term rental units, I would insert for a zoning district has been met. No new applications for short-term rentals will be accepted for that zoning district. In the next line, just a simplification that Carol suggested in the last workshop and we agreed upon was to delete the SR, UR, FSF, FMU, et cetera, all those zones and write instead in each of the applicable zoning districts. Then the next change I had is a substantive one I think is very important to this. If we're coming out of this with entities owning properties that are used exclusively as short-term rentals, I like to make certain that the opportunities, the limited opportunities for those over time increasingly go to owner occupiers. So I would add as a new sentence. After the sentence ending, maintained by the city planning department. A new phrase reading, in each such waiting list, an application for an owner occupied short-term rental unit shall take precedence over applications whose primary residence is not the short-term rental unit that is subject of the license application.
I agree with that, other than the owner occupied is more, it's very much easier to enforce when it's primary residence. It's clearly defined where you file your taxes, yada, yada, but it's the same thought, and that's
If it all holds together, that's fine, but at least I'm going to consistently today refer to owner
Okay,
occupied
now we'll keep
short-term
correcting you.
rental unit, with the meaning of which, the intended meaning of which I described.
And then, so that's like you said, it's more substantive policy. So I'm making a list of your things for you guys that I'm hearing for you to help with a motion. So I guess if you guys want to talk, if you have a majority of agreeing to that.
So I thought we eliminated owner occupied from, in that previous paragraph, Lee, that you put in there. That you tried to say in the definition statement that would not be managed under the short-term rental license ordinance.
That's only if it's part of the home and they're there,
Oh,
right?
gotcha.
Yeah.
But Lee, what you're proposing is that at some point, future point, priority be given to owner occupied
There's,
STRs?
yes,
But-
there's, if there's 5 guys on the waiting list who are, an investor from wherever. Number 6 on the list is somebody in the zone, an owner occupier who has a primary residence there, decides they want to start renting out the property when they travel to Texas for a few months.
I
That
understand what you're saying.
they move ahead of others who are not owner occupiers.
So basically, there's a list of 6 people. One of them intends
Is
to
the property
live in
owner that lives
unit as an owner occupied.
He
would
goes
give them
he goes ahead
priority.
of others who are not owner occupiers.
No, I can't agree with that. I can't agree with it because you're basically turning the whole ordinance on its head. I mean, why have the ordinance at all? If you want to limit it to those people who have 185 days residency, then that's what the ordinance should be about.
I'm not limiting it to that. In fact, there may be others that depend, but to the extent demand by owner occupiers over time comes to fill the entire.
Can you state what the plan to benefit of doing that is that you're hoping to obtain?
What generates the position is that I'm not in love with short-term rentals in our residential zones. But if we're going to have them, I'd rather have them be by owner occupiers. And
Okay.
owner occupiers, they're members of our community. If they wish to rent out some rooms to generate some income, I'd rather they be able to do that than an investment property being the one generating the income.
But
So
that
how's
turns
that
the
different
whole-
than a guy who's here in the summer, 3 months? It's not his primary residence. He owns the property. He built the house 45 years ago, like my neighbor across the street, and it's unoccupied house for 9 months if he decides he wants to do a short-term rental. How's that different that he's
If
here
he's had a
6 months?
short-term rental all along, the list is only for people who have.
I'm just saying, how is it that somebody who lives here 6 months gets priority over somebody who lives here 3? That's what you're saying. Unless you make it more distinct to non-residents or something else. Just setting it by the time of how long they live there, it's changing how one person.
No, it's not saying by the time how long one lives there, it's setting it by their usage of the property. The usage of the property, if it's their primary residence, that's, I'd like to support local owners.
So you're talking
Yeah,
about the
it
individual.
reduces the amount of short-term
Yeah,
rental
exactly.
time that's happening in that neighborhood too, which may be a part of what you're trying to accomplish. Because those people evidently live there more and rent it less because of the constraint you're prioritizing. Okay, I kind of see where you're going. I think
sounds like
it's
a
a little
controversial
onerous to
suggestion.
manage though, because we won't have any idea how long somebody lives in their house.
That's why I keep clarifying. I'm not gonna keep doing it, but if you guys do this policy wise, I'm gonna make it very distinctly defined as primary residence, and that is somebody who has all these governmental documents that that will make it very clear, because it's found not to be able to be enforced, to your point, Commissioner Kennedy, where we just say, oh, it's where they live majority of the time. That you can't enforce that, but you can. Where do you file your taxes? Where's your motor vehicle registered? Where you register to vote? Which you got to sign voter registration under penalties of perjury, that sort of thing. So I'll make that more ironclad if that's where the direction of the policy is from you all.
So are you proposing that we give priority on the waiting list to owner occupied properties?
And you're talking about the waiting list only?
The waiting list only.
So future new
Exactly.
licenses that are issued.
As new licenses.
I would be more in favor of it saying some kind of part-time or instead of primary residence, but it's a
So
proper,
voting-
I don't know,
voting
some kind of thing where they live here part of the time, as
That's
opposed to.
harder to prove. That's
Yeah,
not
I
hard
know,
to
you
prove.
still can't prove it.
I would
I
either do
guess I'm
primary
in favor of it.
primary residence or don't mention it at all, because primary residence is easy to, we could,
Primary residence easy to define, you're right.
yeah. And it's fine, if you're gonna go that route, then just change like what you're doing policy wise, but that's just my recommendation.
I don't know how often that would occur anyway. It may come up once in a while, but if it doesn't happen and somebody claims, I don't know, it creates a lot of extra things to have to check off for the staff. I think it's just by order of application. It's suitable. I don't see why you'd have to. I mean, it does.
I understand Lee's
Yeah.
objective here, but again, it's almost turning the whole ordinance on its head. If you've got a waiting list that, all of a sudden you change the goalpost for applicants and saying, oh, by the way, even though you're on the waiting list, if you don't have your legal residence in the state of Colorado and in the city of Woodland Park, you go to the bottom of the list.
No. Somebody.
You go behind the
You
resident.
don't go to the bottom of the list. There could be a lot of people on the list, many of whom do not have it as a primary residence. But if someone is a primary resident, they go ahead of those who are not.
How would you handle military homeowners that are overseas?
Not address.
That would still be their residence,
Yeah,
probably.
they still would have primary residence. That's why
Yeah,
we
that's
just,
right. That's still the residence.
where they vote, yeah.
Exactly.
Anyway, it's complicated. We have people trying to maintain residency here that don't live here then potentially.
That's what
I don't know how they do that. They just have their driver's license here and everything else sent there.
People have tried in my cities and I've not been able, they've not been successful, the way I write and the way I approve it. Other than military, which I think you'd want, but the people who are trying to scam the system, nope. I believe me, I could.
Well, for the purpose of moving this along this evening, if we want to add Lee's amendment, then add it and then we'll debate it at
Okay,
the final
at least we
vote.
get a draft which has got language and then everyone can see as a group, because we're clearly not going to have a document tonight that we can, at least in my mind,
No.
we're not going to have a document tonight that we can vote on as a recommendation. We may have.
Nina's actually recording these items so that she can give us the bullet list of changes, so we can make an amendment and move it forward to council.
And it's not
That's
gonna
what
be
she's
specific
trying-
language, but yeah, so.
But we don't
right-
have enough, the
Excuse me.
language is not clear enough to. vote.
And with this particular item, I would ask the chair, like you did on one of the prior items, to kind of, what is your sense in terms of where the group is? I mean, is there overall support or not? That would probably be helpful for moving this
Very
along.
good. If we could take a brief poll of whether we support the proposal by Mr. Brown to include primary residences as a priority on waiting list. Carol,
No.
Lee?
Yes.
Yes, for my part.
Yes.
Yes. Mr. Kennedy.
I'm not really in favor of it, but I don't have a strong objection. So if the majority wanted to go with it, I would continue to move forward.
Right
I
now,
wouldn't
you're
stop.
the deciding vote if we were voting.
No, it's three.
No,
No, it's already been decided.
I'm sorry.
It's already 3-2.
Didn't later, not counting well.
I don't think it's necessary. I don't think it's necessary. So I would say, no, I would.
Majority in favor.
I don't
of the
I don't
amendment.
have a strong objection to it being put in. If a majority wants to put it in, I would keep moving forward.
Only for the waiting list, I could.
Exactly.
Yeah,
Only for
it's,
the waiting
that's,
Okay.
it's not going to come into play that often.
Okay, so that was helpful to know that the group really would prefer to have that added.
Yes. Anything else on section H?
Well, I think that there's a paragraph here that says that the waiting list shall be annually prepared and maintained by the city planning department. Well, I always assumed that the city clerk would continue to process short-term rental with the city.
Or is it the director of finance? Because that's where they get their license.
Most cities had city clerk, but I was told in Woodland Park, it's gonna be the planning department.
For maintaining the waiting list?
No, that's the inventory. I think it's appropriate for the planning department to do the inventory, but the waiting list ought to be the city clerk.
Or the licensing issuing department?
Yeah. Who issues the business license today? City clerk?
I don't know if it's the city clerk. It happens, I thought it would happen through the finance department.
Well, whoever it is, that's the appropriate one, not the planning department.
Moving on to I, short-term rental businesses must, et cetera. Any comments in there?
Which one again? Sorry.
I.
All right.
While you're looking, Lee, I did want to make a comment on something one of the speakers during the public hearing had mentioned about requiring insurance. There is a reference to that in the application for the applicant. They have to ensure a certain level of insurance on the facility.
One, and there was a comment as well for public comment that relates to I, pointing that one doesn't need a contact person when the property is not actually being
Yeah,
rented.
that was a good point.
I think that's true, of course, but I don't, it's not clear to me that the contact, maybe, I had always read it to assume that was how it was to be read, but if it's not clear, we should make it clear.
I think that was a good comment. When occupied, the local contact person must be available.
Must be available during periods of short-term rental.
Occupation.
Okay, during periods of
So you're giving
occupation.
this local contact person a break when there's no need for them to be there.
Did you get that, Nina? The local contact person must be available during periods of occupation. 24 hours per day, et cetera, et cetera.
Yes, that's a clarification. I'm just ready putting it in. I don't think I need to add it to my tally of amendments for your motion, but yes, I got that.
Anything on J and or K? Moving to the next page, L. 500-foot radius.
Did we want to change the UR requirement to something less than 500? And that was going to be based on a recommendation from planning department. Obviously, smaller lots, so why penalize a smaller lot? The same requirement that you would do in suburban residential. My recommendation is 250 for urban and 500 for suburban. And that's, I just pulled that out of my fourth point of contact, so. But we thought, yeah, we thought you guys were gonna say, oh, in urban residential, they're already this close together.
Apologies, do not have that for you.
Okay.
I like your idea, Carol. 500 for suburban and 250 for urban.
The PUDs would remain 500.
Well, PUDs are such a unique animal. I mean, it's.
I
Yeah.
wouldn't even include them. I would just do urban and suburban. So. And PUDs would be by exception and be at the discretion.
I do want to ask a question while we brought up the point of PUDs. For some strange reason, I don't know why, but Woodland Park all of a sudden becomes a destination vacation like Breckenridge. And somebody wants to do a PUD of condos that are totally short-term rentals, no long-term stayers. It's all for some reason, they want to do that. Wouldn't we, at a time of a PUD, be able to assign that use to that property somehow when they
Yes.
request it? If somebody wanted to build a set of condos like a lot of Colorado towns have,
Yeah, like
that are
timeshare.
places to rent, like, I don't know. I mean, would that come under a short-term rental? Or was it just a business and we set it up as a PUD if somebody wanted to do that? I mean, it doesn't really apply because it probably might wind up in a commercial zone anyway. But I would think PUDs are uniquely identified as they occur. And the ordinance should allow for us to have the leeway to approve a PUD for that use if it's appropriate for the city and the plan.
This would apply to existing PUDs is what I'm assuming, and then new PUDs could be
Set up as we
Exception.
deem.
Reviewed.
I mean, they'll get set up uniquely, right? It would, again, probably be a commercial project or something, but I just didn't want our ordinance to be in conflict with some other PUD event that might occur someday down the road. I don't know.
Are we talking about just for the radius?
The radius, I'm okay with the 250 for urban rather than 500.
And then nothing for PUD, is that what everyone's saying?
I just asked the question about the PUD for,
Okay, I'm just making notes.
it doesn't reply to this.
There's two issues, existing PUDs and future PUDs.
It should be,
Well,
they should be able to take care of themselves if.
Well, existing, this would be a new condition to an existing PUD, so it would have to be reviewed, wouldn't it?
Not as a short-term rental.
No?
Yeah, it's set up in the use table as permitted conditionally in the PUD zone. The lot sizes in a PUD can really vary depending upon what's going on. You see everything from single family lots to the potential for apartment buildings. Those are pretty well.
And
excluded.
dormitories.
Dormitories are excluded and other provisions. So when you're into housing types that are attached, within a PUD or on smaller lots, you may be better served to just go with like a 250-foot radius and be done with it.
That sounds good.
For everything?
In a
Well,
PUD.
PUDs.
Oh, okay,
PUDs.
okay.
Yeah, so your urban residential in the PUD zone would have a 250-foot radius, but that suburban residential that has a larger lot size would be the 500-foot.
All right.
We're agreeable to that?
I'm agreeable. Before we finish on it too, I think we talked about last time that the radius language doesn't really work where where is the center of the radius? These things are ordinarily measured the separation from property line to property line for. I've got this here. I figured where we're gonna, I've got some sample language.
I saw this in the Colorado Springs ordinance.
Get them to Karen so she can fax it in. if this has 200 feet. I wasn't sure where we're coming out in the urban district, but.
Well, 200's good.
No, I wasn't trying to. I'm not arguing. I'm not arguing.
No, I just said I just thought 250 was reasonable, but 200 is probably better.
Well, the property line to property line is different. If you kind of imply radius and you said from the center point of the unit or whatever, it gets implied by the fact that you're going to draw a circle around it. You know, property line to property line is probably a shorter distance than if you imply a radius, and you know, so you got to have a center point from and then out 500 feet in every direction.
Yeah, it's.
Does it include the
Yeah.
garage?
How you
Does it
do
include the
exactly.
house?
So property line to property line can be
Property line to
measured.
property line is how it's
Property line,
done. That's how it's
property
done.
Right,
Yeah.
Or property line distances.
Anyway, I'm okay with 250 for the urban.
Okay. From property
Yeah.
line to property line. Gotcha.
And as Mr. Zalaga made comment earlier, would be convenient to have a map so we could see what kind of limitations that actually places.
It
We do have
would.
a map.
And also if, one possibility if.
When
if
you look at the
aspects
air
was,
DNA,
we would anticipate that this creates particular problems with the density because the time to adjust is, you know, if there's a bunch of properties that people are trying to change in, it may make sense that the density rule be applied starting in 2024 rather than 2023. That would allow additional time for owners to adjust. I mentioned a possibility. It's one you could. Yeah. But then
there's a
people would
data
know ahead of
collection
time and give them extra time to deal with it.
the data collection website AirDNA shows properties that are advertised as short-term rentals in Woodland Park. And it has, you know, which locations. And I would say that the suburban residential is not going to be impacted significantly by the radius limitation currently, the way they're spread out. The urban residential is much more dense. And however you look at it, the bulk of our short-term rentals are in the commercial district, where they're really
I just mentioned
heavily
because of
populated.
because of that, if there could be a large number of property where the situation has changed. I'm
Yeah.
not trying to be harsh in any of this. I'm trying to. You know, allow
Oh,
for
yeah, but it'll affect some people,
change.
but
All right, I'm not proposing it. I just mentioned it as a possibility if it looks like, you know, further review.
when it comes time to relicense is when it'll affect some of the urban residential short-term rentals. Most
I do
likely.
think it's important to add property line as the
Yes.
delineation.
Right.
Yes.
Yeah, that's at least measurable.
Item M. Any comments?
Okay, well, it does raise, I think we talked about this briefly at maybe not more, everything's more than brief, but during our last workshop. They can have a parking plan, but the parking plan, it is what it is, and our staff isn't gonna be able to do anything other than say, did it provide for two parkings? Because these are houses and residential units. There's a parking standard that's set forth by the city. It seems to me that what we may, that's fine as it is. It seems to me that something that should be added to this, to the end, one of the sections at the end, should have a provision, adding a line to the table, the parking table for short-term rentals. It says something like 2 plus 1 car for every bedroom in excess of 2. I'm jumping ahead to say add it, but I would add, and towards the end of it, it's touching a different section of the zoning ordinance. But as it is now, there's, I mean, most of the cases, it's just going to be 2, and 2 isn't going to be enough if you've got places with more guests in it.
Well, how do you account for garage space?
Well, that's the parking space. They have
Okay.
if the garage space that's one thing they can do in their plan when they bring it in, say the garage is available for tenants, or the garage is not available for tenants, or oops, I don't have a garage. I mean, there's different choices.
Gotcha.
I like that idea instead of having a plan. You could
Our
say,
current car ordinance is by residential
Mhm.
dwelling unit, correct?
Yes.
It's not by how many bedrooms or how much occupancy a house has. That's not
Actually,
in there.
apartments, it goes up by number of bedrooms. For houses, it doesn't.
Okay. So it would need to be there for short-term rental information, that it's by number of occupants or something.
So this is one where I would leave M the same, but
I-
one of the sections late.
Yeah, I understand. what you're saying. I think what you're saying, Commissioner Aaron, is that we should amend our zoning, the zone, Title 18 to have another section for short-term rental.
1878050 B4, the parking table.
Right, and then what do you all think it should be? Is it are you saying each bedroom plus two? What are you, just so
I
we could,
suggested two, it should be 2 parking places per each one, plus the number of bedrooms available for rental. Let's see, did I get
so like one space per
2
bedroom?
bedrooms plus 1 per for each bedroom beyond 2?
Got it.
Well, that begs the question, someone brought this up during public hearing, is that we did not specify the maximum number per short-term rental unit. And we need to do that somewhere
Yes,
in
we
the
do.
ordinance.
Yes, we do.
And I
Yes.
think what we had agreed to at the work session was 2 people per bedroom plus 2. Of course,
That's what I
that contradicts what is allowed in a residence in our zoning, which is no more than 5 unrelated adults, but this is a new section of our ordinance.
And actually, very often people are related within the groups that come.
Oh, I know they are. I think I had some sister wives in my community, but that's another story altogether. I don't think they were legally related. Okay, but that's got to be put in there somewhere.
Okay, rather than the actual parking table, I would look at, it's on page 7 of the ordinance, the proposed ordinance, Nina, where we've got short-term rental unit standards.
Which is page 7, there's no page numbers.
There's actually a page 7.
There's no 6 on the table, but the one after the table is 7.
The ones in the middle don't have numbers, Lee.
Oh, starting with the first numbered page, you got you.
Yeah. So the rationale is when somebody's applying for a building permit for a new house, very rarely is it a situation where they're applying for a short-term rental. It really is a residential dwelling unit,
Mhm.
single family versus multifamily, that potentially gets used as a short-term rental. So for that reason, the parking standards as they exist for, single family home, I think are adequate. It's when you want to use it as a short-term rental that this provision as outlined in here with the additional standards that need to be met.
Add a standard in B.
B6 specifically
Right.
talks about parking, would be what gets looked at when somebody's wanting to do the short-term rental.
Okay.
And I agree that this probably should be a little tighter than how it is currently written.
Add a number.
As well as in here talking about that desire to set up what is the occupancy limit of a short-term rental, that this would be potentially a good area to have that detailed more.
Well, then what you just said then makes sense, Karen, that on page 7, under section 6, short-term rental units,
I would say new 7, if I could.
you go
propose that.
down to parking requirements under 6, under B6. That'd be the appropriate place to put that kind
Yes.
of language.
Or I would probably add a new 7, but. And
So we
then
should do- we should
it'll be
do-
very clear, 2 parking spaces for, what was it, 2 parking spaces for 2 bedroom and then 2 spots for each 2 bedrooms after that?
Yeah, we need to delete the place where it is meet the off-street parking standards for that particular unit
Great.
and say.
What it is.
Provide not less than 2 parking spaces
Okay.
plus 1 parking space for each bedroom made available for rent.
There you go.
Can you say that again?
No.
I don't think
I
it'd be
help me,
physically
I probably, I
possible.
messed up
I
the
think,
wording. He's
uh,
right. I think I got it.
No, I just meant the general theory.
These
When we
parking
make a motion, it's gonna be
spaces-
general, sorry.
And I want to poll Nina here quickly, since you've written so many different ordinances like this. Have other community, I mean, I guess, what have other communities set up for a parking requirement? Because I guess one of my thought is, and I'm going to back up the bus here slightly, because we need to clarify the language on the occupancy limit of the STR.
Those two
And-
separate oh, sorry.
Yeah,
Let's
no, I want to back
do
up
parking
and
first.
kind of flesh that one out first, because I think it'll make more sense logically. So as
So
I
they just said
understand-
two people per bedroom plus two.
Plus, per people, per legal bedroom. I don't want people saying, I got a hammock on the porch and it's a bedroom.
They need to come into with the application, presumably it's got.
Okay.
Didn't it say, didn't the existing line say we have an occupancy limits established in the application?
Yeah, two people per bedroom plus two people.
Well, actually, I have some language.
And then from that, is it one parking space for every 4 occupants or one parking space for every 2 occupants?
Can Karen, I think for just because for parking, it's hard to say per occupants because that changes all the time. So that's why like, so let's do a maximum occupancy and then what other places
Do it
do.
off of maximum occupancy.
Oh, yeah.
It works just as well off doing it off of maximum occupancy as doing off a number of bed. They're both calculated.
Maximum
based
occupancy,
upon
yes,
Number of bedrooms, so decide what we want to do.
Yes, you're correct. In maximum, if we're gonna say maximum occupancy, but not, because otherwise occupancy changes every day. Yeah.
What is that number?
Yeah, I was gonna say, so it sleeps 10, it sleeps 4, it sleeps
can-
6. How many
yeah.
parking spaces is that?
Well, based on your proposal, it's 2 minimum,
Right,
and then 1 additional for each bedroom, so.
beyond 2.
So one bedroom would require 3 parking spaces?
I said each bedroom beyond 2.
No,
Okay, so 2 parking spaces minimum. And then for the third, fourth, and fifth
Third bedroom
bedrooms,
means 3, 4
Yeah,
bedrooms
each
means
of-
4.
well, okay.
But
So
that's, that, it may not be physically feasible.
I think you should add 1
If-
parking
if
space for
they're
each
not- if
additional
They
2
don't have room
bedrooms.
for 4 cars, you don't want a 5-bedroom place.
That's right.
or you
And if
or
we're
you
not
can't
having
lease
short-
it to-
Or they're gonna have to limit their occupancy.
I think 2 parking
That's the
spaces
whole point
plus
of this
1
rule,
for each
because they'll
additional
be-
2
they'll be
bedrooms.
on the street.
Yep,
Right.
that's a good point. That's another limitation.
Mhm.
And then,
So-
geez, I wish I'd made this a long-term rental.
So is agreement 2 parking spaces for 2 bedrooms and then plus 1 per bedroom beyond 2 for parking?
Yes,
And then for occupancy, is everyone agreeing to the 2 per bedroom plus 2 people?
yes.
I agree with the 2 per bedroom plus 2 people. I think it should be the 2 parking spaces and then an additional parking space for each additional 2 bedrooms. Not just 1 additional bedroom, 1 additional parking space. Just, I think, a bedroom's 2 people and 4 people fit in the car, almost every car, so. I just think you got way too much parking if it's a 5-bedroom place. It's 2, 3, 4. That's a lot of cars.
So if I-
It could happen, I guess, but I think you should just provide adequate parking for all guests or something like that. If they can't park on the street. But
Agreed on that, but how to quantify it?
yeah, I know.
Minimum 2 bedroom or 2 parking, and then 1 additional parking place per 2 additional bedrooms.
That's what I was thinking.
So
That,
So
3-bedroom
a
house would take 3.
6-bedroom house gets only 4 parking places. And it's used for short-term rentals.
Yeah.
6-bedroom house is gonna have 14 people. 4 parking spaces, huh? If everyone comes.
I
in-
see. You gotta
that's
add
not
the
way I've
plus
seen
2.
People come in.
I got you. I got you. You got to add for the +2. It's how many per bedroom +2. So I wouldn't count quite the same number. I'm fine. You can add a parking space for each additional bedroom.
And for each.
If they've got that many bedrooms, they should have enough room for parking.
For each additional bedroom beyond 2, is what sounds like we're agreeing to.
limiting how far away from the property next door. With all due respect, I'm sorry. to interrupt you.
But we can do that. We can do that in the application process. There's no off.
It's on site parking is what
On-site.
I'm anticipating, not off-street, or off-site or on-street parking. Okay, we were covered 4 and 6 on this section, but I think we were back on I a couple pages ago.
Page 4,
On page 4.
applications.
I do have a question for the planning commission that just came up with regards to the parking. This short-term rental license is also going to be issued for commercial zoned short-term rentals
Yeah, of course.
in our downtown area. I guess it makes sense that that still applies, right? The off-street parking?
It's a valid question.
I don't know what these properties look like in our commercial zones, but we,
How about a provision like it says
in
either
certain
in
residential
certain
zones.
zones or in any, that the planning staff may agree to a reduced.
That's why I had the parking
reduced
plan
limit if
language.
the circumstances justify it.
Sorry, Nina, you had a comment?
That's why I had the parking, just the parking plan. So the planning department looks at it and then they decide. Otherwise, I would recommend not like the exception language, but maybe certain zone districts, like your downtown zone district, if that's what you'd like to do. But that's why I originally had the language, the parking plan language, because that's just the planning department would look at it and say, okay, this requires this many, but
No, I think you need a separate standard for short-term rentals.
right. But then you shouldn't have exceptions just because the planning department says so, that's a little, either if you're gonna do it, maybe pick zone districts or pick, like sometimes they say other than the downtown commercial core or whatever the overlays of the districts are. that you wanna do.
I guess my suggestion would be that the language they've already come up with is a place to start. And
Right.
part of the reason I suggest that is when somebody is proposing a commercial lodging establishment, parking gets reviewed as a part of that particular application. And because those rooms generally sleep 2 or 4 people, maybe 5 if there's a cot or a rollaway that's thrown in there. You typically see that as, 1 parking space per room for rent in a hotel. With the short-term rentals, to get a house in one of the commercial zone districts where they can, that goes through that change in use process. And part of what we look at is, do you have the 2 parking spaces for the residential unit, in that zone? And now with somebody then wanting to use the house for a short-term rental, I would say they still need to be able to demonstrate the parking standard we're asking for here, partly because in those commercial zones, especially in and around our core here, some of those businesses are already competing and fighting with one another over available parking. So to throw a bunch of other cars in there that aren't as mobile as the people that are in a restaurant for a lunch is potentially problematic. So I personally would recommend this as a safe place to start in terms of how this gets looked at and reviewed for short-term rentals.
And you have that analysis when you're doing the commercial applications based on the location. I'm thinking of Bill Page's apartments that are on the backside of Gold Hill. But for residential, this gives us a holding place. It says, okay, at least 2, and then 1 more per bedroom.
For when you're doing as a short-term rental, yes, as long as you're,
Yes.
because the needs shift a little bit, with the short-term rental, which is the whole reason we're here.
Yeah, that's right. You have
Okay.
personal experience.
Well, looking at the clock, it's 9:39. We've been here for more than 3 hours. Without a break, is break being requested?
Yes.
Let's take 10 minutes. Thank you. Mr. Kennedy, you available? Yes.
Yes, I am available to continue.
Seem to be missing counsel this time, so we will
Wait.
wait until her return.
She's the note keeper.
So we'll continue our recess.
There she is. Yep, she just.
Oh, Nina's back. Very good. Let's continue our discussion.
Are we recording, Dave? Perfect, thank you.
Got an hour and 10 minutes.
Okay, so where do we leave off? We were on page 4
Yes.
and applications, insurance. Any comments on page 4?
Several times during this section, I see it calls the city shall, the city may, the city. Who is going to, I want to know who is going to be responsible for administrating this ordinance? Is it going to be the finance department, city clerk's department, or the planning department? And that's who it should be.
What sections are we talking about? Speaking about being the note taker.
We're on page 4. And we're looking at 5.22.030.
Okay, so I had city clerk because everywhere else, the city clerk does all business licensing. Then it seems to be that it was going to be in the planning department, and then it was unclear, so I took it off. We should not put this in the finance department, that they're not, definitely not. It should be either city clerk or the city or the planning department, and it could be city clerk and their designee, which is the planning department, but I don't know if Karen has any ideas.
I was working under the assumption that I don't know how things are currently worded under Title V for how business licenses are issued. The bottom line from a practical standpoint is it's the folks in the finance department that are actually processing that business license and issuing that. So I was under the assumption that the short-term rental license was going to happen similarly, but with basically a planning sign off that says, you know, they've demonstrated or met compliance under the planning terms. Since we don't issue licenses, we issue permits around things, but we're not a licensing entity. We're not connected to sales tax. We're not.
So yeah, sales tax nothing to do with it. Business licensing should be city clerk. There's nothing in the code that says finance department. The finance department is not the same thing as you're saying. That's for your department, even less. So I could put city clerk. That's why I put city, because that seemed better given what goes on in Woodland Park, the way what you're explaining. So we could always just
But Karen, doesn't the finance department monitor and maintain that software program that identifies short-term rentals on the social media platforms?
They use that for the tax
For
collection.
tax collection, okay, so in this section doesn't talk to tax collection, it only talks to applications.
Right.
Okay. So do you think the city is in general serves a purpose, or should it say the city clerk?
I think it should say city clerk.
that's what I had before. So I'll put it back.
You're right. We talked about the licensing before. And that's where that comes from, that section, the
Okay.
business.
I had city clerk up until the strap, so I'll put back city clerk.
That's several places, Nina.
Yeah, I'll look at the former version. Yeah, I had city clerk everywhere. I know you're right. Thanks. I know you're talking about Larry. I changed.
Any other comments on page 4? Did you have anything? No. Turn to page 5.
Yay.
Do we have any comments on this page?
No.
Lee, Mr. Kennedy?
I have no additional comments. The updates from our work session look good to me on this one.
Move on to page 6. Talk about penalties. Working down the page, we go to the use table, and we've had discussion about that already.
Yeah, just took out 3 columns, right?
We
Eliminated
eliminated,
MHP, deleted the PCs.
correct.
And above that, 1806.481 deleted the word residential.
Yeah,
Short-term rental unit.
I was just gonna recommend it to be just the same definitions that we use for licensing. the-
Dwelling
also be-
unit.
Yeah, you're, I already have
Request
it down.
And just to clarify, Karen, the PC permitted conditionally means they're allowed as long as they comply with the various conditions, but there's no public hearing or review
Correct,
as in a conditional use.
correct.
And I kind of assumed after we talked about this last time, that permitted conditionally means that there is a specific section in the code that deals with this particular use. And that's what this would be. And this particular use has standards and criteria. And I just thought it'd be very helpful to talk about that, and explain what that meant. Maybe it just confused things if we tried to do that.
I put,
Have
to
an
that po-
understanding.
to that point, I put short-term rental units in accordance with chapter 522 and section 187850, so it kind of points you back there.
Yeah,
It's-
you see
yeah,
that
the
on the
tables
next
On the next
page.
page, yeah.
Larry. It just got,
That's already more explanation than most of them have. They just say PC usually.
Okay.
Yeah.
Very good. Well, can we turn the page then? Page 7. And we had some discussion on item B4 and B6, the bedroom or the occupancy. I think we said 2 per bedroom plus 2 additional occupants per unit.
Yeah, which paragraph is this? I just lost.
B4, page 7.
Right, okay.
well, and here would be my recommendation that in 4, in addition to defining the maximum occupancy, and add there, large events exceeding the maximum number of allowed occupants will be prohibited, and then strike 5. So there's no, if somebody says, well, you only said I couldn't have a party, a concert, or this or that, but you didn't say I couldn't have this event. So I think to me, it's clearer if you say no events with more than the maximum allowed occupants.
I think we were moving towards the direction of figuring out what a maximum occupancy would be.
Yeah,
when we talk about parking. And I think we need some kind of language.
Well,
here.
and I would do that in B4. I would say, I would state clearly the maximum occupancy would be limited to 2 people per legal bedroom plus 2 additional people. Large events exceeding the maximum number of allowed occupants will be prohibited.
There you go.
Actually, even all of any event or non-event.
Correct. So why, just say, well, do you need to say events, just events exceeding activities, maybe? Activities exceeding,
Okay, occupancy, we don't mean just the number of people that can sleep there, we mean the number of people that can hang out there. Is that the point?
Yeah.
Basically making them
Okay,
the
so you
same.
mean activity, you're right, then it should be with activities.
activities exceeding the maximum number of allowed occupants will be prohibited. And that keeps the ad hoc party occurring. Oh, I was down at the Inn and I met my new best friends in Woodland Park and brought all 50 of them back to my STR.
For your book club.
Yeah, my book club.
That was a joke.
Nina, can you, when we're, it's maybe going back a little bit, but when one gets a license for this, oh, I'm sorry, when one gets a license, do you get a single license for the business and the short-term unit, and it's sort of planning chopped off on the short-term unit part of it, or is it? Because ordinary, we've had a business license before, we're adding something for short-term. do we still have two licenses?
I wouldn't recommend it. It probably should just be simpler.
Okay, well, I'm just asking, we ought to know what we're writing here.
The short.
Well, it's right now requires a short-term rental business license. It doesn't speak to the other one, so that's what.
Okay, as a short-term rental business license, does that have anything to do with the business license or and one thing I mentioned comes up in 6. In 6, it's called a short-term rental license. Most places elsewhere in the draft, it's called a short-term rental business license. Is that the same as the business license one gets from the finance department?
It's a more specific type of business license that I would recommend in practicality that it just be one, but we'll have to ask staff.
It's a single license that comes from this process. You go to finance with your check. They handle it, they send it over to planning handles it, planning sends it back to finance, and finance gives it, and it's a single short-term rental business license, is that it? Or
I believe I have to go over this with staff, and I don't think it needs to be specified that specificity in the ordinance, but we'll speak with staff if they agree with what I'm saying, because.
All right, and in 6, then I should write short-term rental business license instead of short-term rental
Yeah,
license.
I thought I'd change that everywhere, so I'll just make that change right there. That's I'll do it now. Thank you. I appreciate that.
Okay, and just the fact we call it a business license makes me think there's not another business license and they got combined both.
I was told to
We
be.
didn't call it a
clear,
short-term
so I
rental
changed-
license, we called it.
That's why I put them in
short-term rental business
because
license.
it's a bit, it's consistent with what everyone had asked from the last work session, which I agree to make it consistent. That's why I capitalize it. It's short-term rental business license because it is a business. So that's a type of business license. It is.
And as a point of information, businesses are allowed by code in residential areas. You just can't have outside advertising. I mean, there are
Home occupation.
home occupied businesses are allowed. I've heard a couple comments that said businesses are not allowed in residential
I mean,
zones.
they're going all the time, lots of.
Yeah. Yeah.
Back to one of the points we were discussing, which was item 5 regarding large events. I would actually suggest keeping that phrase and maybe throw the language in large events such as, but not limited to. So it is very broad. And the reason I would keep that is it provides examples. And after having to drill into the nuances and prove to somebody today as to why they needed a permit for a fence, sometimes it's helpful when you've got things that are
I agree.
that obvious, in the
Okay.
ordinance.
Okay.
Keep it in.
Sure. With that caveat.
Yeah, I understand you wanted to make that other adjustment.
Now that we have occupancy, it makes sense to be more clear, like Carol spoke to. So, but
But keep this provision also.
Yep, I
Thank you.
agree.
I'm okay keeping it.
Okay.
I'd like to recommend we're still on overall B. I'd like to recommend new language. We're read right now. Short-term rental unit standards. The following standards shall apply to all short-term units within the city. I'd strike that and replace it with short-term rental unit standards. The city planning department shall review and either recommend approval or denial to the city clerk for all new and renewal applications for short-term rental units licenses based on the following zoning standards.
I'm sorry, I didn't know where you're reading from.
It's a proposal to change the language in B.
Can I just chime in, Larry? Because I did accept most of your changes from your prior version, but I think this is better to be clear like this because I cross-reference this section other places that in that's new title, Title 5, whatever section 2, that they need to follow all the standards. And it's just more clear. These are all the standards that apply in our zoning. And then we cross-reference it other places that you have to follow all these rules to get renewed and that sort of thing. We already speak to that in 522.
And I appreciate what you're wanting to say. And it sounds like you're really trying to spell out the administrative process.
Which is already above.
is as opposed to that this section really is just the standards. that
Standard.
need to be
Yeah,
met.
that's what I
Just
said.
give the
So,
standards. but-
Yeah,
That's a better way to say it, yeah.
And I've got two additional standards that I'd like to see applied here. Because I know that this is under zoning, and like you just said, Karen, it's going to be reviewed at that time. But one is that short-term rentals shall be permitted conditionally only within the zoning districts as specified within City Code Section 1809-090, Table of Permitted Uses. And then that just clarifies, it has to be within one of those zone districts.
But in the zoning chart, we say we reference them back to 1878, 50.
Right. It's allowed use in that zoning district per that table.
Every
Sure,
use
it's
is,
necessary.
every use is only permitted.
Well, we're under the section dealing with zoning requirements. And under this zoning requirements, we have standards. And one of the standards ought to be short-term rental units are only allowed in zoning districts where they're approved.
That's already done by the use table, isn't it?
Yeah, every use is, yeah. okay.
I think it's redundant, Larry, but.
Yeah.
I don't see the need.
It's
Well,
already covered by the use table
again,
saying
that
you
is
can
a-
only have them in those
A
zones.
good standard to apply. But that's my opinion.
what was your
I-
point?
I'm not hard over on that. I just don't think it's
So
necessary.
again, I don't see the need. Mr. Brown, do you have any comment?
I'm comfortable with it as is.
Kennedy?
I'm comfortable with it as is. I think that's covered in another section already.
Okay.
So what's your next one?
And then-
Another one?
Try again.
Okay. Ensure that the maximum number of short-term rental units within the zoning district shall not exceed the established amount of the total number of residential dwelling units currently located within those districts. And it's again, just to make sure that we are maintaining that inventory, we know what they are, and that we're not going to exceed them. And again, as a responsibility of the planning department.
Which is covered in that section that talks about the waiting list,
Yeah. but
the established cap. So you're suggesting that we just reiterate that under standards, the essence of that one.
Exactly,
Okay.
exactly. And that gives teeth to that provision as being a zoning standard.
Got it.
I don't object to that.
I don't object. I just think less is more, and since it's already stated, but you're right. I mean, it does bring home the fact that we're limiting STRs by a cap of percentages of available
Yes.
units. Okay.
So Nina, do you have suggested language for that? I saw you nodding in agreement.
So for the, I'm making a list of the changes that people are proposing. It's not gonna be specific, always specific language, and that's what I'll do after, but like I'll read everything that I'm hearing. But it's not exceeding the caps, I believe, that in the 522 language, so I'll have to go back to that, how we say it there. Is that, did I not hear Larry correctly?
Yeah, that's what I was intending, but added as a zoning standard.
Right, but just similar language.
Yeah, very simple.
I did, that's why I'm not writing exactly word for word, yeah.
Okay.
Thank you.
Section 6, any comments on section 7?
I'll just make a comment that section 7, together with section 8, right below it, those two things do a long thing to try to keep this to the point and addresses how late we are in the year. So it can't carry over to the next year. I think those two provisions, 7 and 8 are addresses those, and I expressed that concern last time, and so I feel very good about those two.
Okay, and then as always, severability, any comments on that? Okay, taking us to 10, which is effective date.
Is everyone comfortable with 7? I'm just reading it again now. It's just-
There
Does
is
it
a
say what you
language.
think
No, there's a little bit of a language issue there,
more than a
especially in the
little.
second to the last line, and I had already flagged that for Nina. That there's, the short-term rental is duplicated in there in ways it shouldn't be.
Yeah, it's.
So that's part of where you're.
Yeah, I already deleted that.
That's part of it, but the basic point is a city should process short-term rental business license, says, I guess, supposed to mean first, before processing subsequent business. So it'll process.
Oh, no, that was a mistake.
Or those that are received of the same type after that or something. It doesn't make any sense.
Yeah. Nina, did,
Yeah, because I amended it and I think I replaced the two, I did a replace thing. It's just saying that if you have a current, now I'm in the language, but if you have just to make it clarify, I don't think it's part of your amendment, but if it's, if your current business license that you're operating a short-term rental now, you'll be considered first.
Exactly. You don't go on the waiting list, the current people get in. We know that's the intent.
Well, not the waiting list.
It's like that.
I understand. I'll fix it to make it more clear. Thank you.
yeah, hang on a second.
I had something different before. I think I did a formatting thing. I understand. I'll just make that more clear.
The language I had sent to Nina reads that, sorry, it's a hard part for me to read.
I know what everyone, I think I'm just making that more
If the
clear.
number of short-term rental business license applications submitted exceed the cap imposed by the ordinance, the city shall process applications from current short-term rental business license holders first before processing subsequent short-term rental license applications.
Wouldn't be something before processing other, not just subsequent, you're processing first. It's before processing other.
Yeah.
And that clarifies.
Yeah, that's something like that is what we need.
Yep, I'll make it more clear.
So.
I guess that takes us, nothing else. We've gone through all 8 pages. Any issues that have not been addressed that we would like to at this time? Not seeing any comments, I guess,
Now you'll entertain a motion?
well,
I would make a motion that we continue the meeting to another date next week, after which time we'll have an opportunity to read a new draft, which incorporates the many changes necessary that were discussed last workshop, discussed again today, plus what other new items came up.
Are you suggesting a date certain?
Well, we need a date certain too. I was hoping as I got that, someone would jump in and say, that should be next.
Christmas.
This room will be, the city
We can
council will be in
impose
this room next Thursday. So
Yes.
that's probably not a good day.
We,
We have items on
Wait a
the
minute, wait a
agenda for
minute, no.
October 12th.
actually, is there a council meeting next week?
Is there a council meeting?
There,
The moratorium?
I don't want to do it after. That means we start at 8 o'clock or 7.
You know,
But I'll argue that in 1 week, we're going to ask staff to go ahead and prepare. I'd like to have the opportunity to.
More than a
read
week.
it, To
Okay.
understand it, to make sure the changes
All right.
have been made.
Nina, how long does it take you to take these comments and put them into a new draft to us? We don't need a new set of, we don't need a new package from planning department for this. We need a new draft.
Just
Not
do
very
it.
long if that's the way you all agree. You can it happens all the time, a public hearing and you make amendments, and that's what I was making a list of, and then that's what you direct me to give to city council. So I just want to make sure that a majority of you want to continue versus take the amendments you gave, trusting them understood and, write them a certain way and then give them to the council for their consideration.
Okay,
So what is?
did you say how long it will take for you to prepare a revised draft?
I did not. I just want to point out, like, before we go too far that way, is that you can make a motion now and recommend to council with the amendments that recommended amendments, that then we take in.
No, this is complicated enough, and I want to see a document that says, it purports to say what we think we were agreeing upon. I'm not ready to vote on a document now. Maybe somebody else, make a new motion if you want.
Well, if you guys make a motion to tell us to do something, we're going to do it. I mean, I'm bound. That's my obligation.
Well, I agree with Lee, though. Just simply waiting for an amended draft without our ability to look and make sure our thoughts are captured is important. The other question I have is, if we continue this action as a planning commission, does that reopen a public hearing?
No, we're going to continue this here.
Continue this hearing and we don't need
Well,
a new notice.
when I say public hearing, I mean public input.
No public input. We'll have to, people who are here they can come back or something too, but there's
no more.
It says
public
it's
input.
continuation. Our notice is what we're giving right
Well,
now.
and I
We could
just
do it
want to make that
tomorrow if
clear. No,
If we had
no.
the document and enough time to review it. But
Well, looking at the calendar then, do we want to make a motion to continue this public hearing until a date certain? And that could be,
It depends upon what Nina tells us.
well, Nina's, I want to have at least
A week would be
a
nice.
week, to read this.
Well,
And we don't have to go on a Thursday either.
I'm.
Council's needs.
Excuse
I
me?
can,
What are city council's needs as far, does city council have anything already scheduled when they're gonna act upon this matter, when they need something from us?
Yeah, Robert just said that's going to be on the
Well,
29th.
Robert just told us that they have a special meeting to extend the moratorium.
On the 29th.
So that need of having.
it's going to be at 6 p.m. It's hopefully not going to take more than 10 minutes, but that's at 6 p.m.
Yeah, well,
Can we
we
do
hate to start
6:30
using up
time
their
for-
extended time. but
Starts at 6.
There's
just
the
more than
council
10
meeting will
minutes.
start at 6. Okay, so we can
Not
start
take more
at
than 10 minutes. Yeah.
Oh, okay.
Wait a minute, I want to have time to read.
No, first I want to hear when we're gonna get the draft, and then I will add, we can
Okay.
add some days to it.
I can do it as quickly as possible. I would like to know that I'm off for medical procedures on October 4th for like 2 weeks. So I think 29th would be good. I'll just do it today. I'll give it to Karen. You'll get it. That's a week. I mean, that's 6 days. It's everything that you
It's a
said.
week?
Evan. To meet on the 20, you guys meet on the 29th after council. Or
All right, well,
So
if you're not free, I don't know.
So when you propose we could have a revised draft?
Tomorrow is what I'm hearing. Probably
Yes.
End of day tomorrow.
They make sure we do it. Yes, yes. If you're gonna do it, if you're gonna meet next week, then I'll rush
You
to
can
do
have a
it.
revised draft tomorrow. I can see meets Thursday at 6:30. I'm okay.
Yeah, I am too. I have no
Karen,
light.
are you available next Thursday?
Me?
Yeah.
I assume so. Yeah, I don't see anything on my calendar at the moment.
That would be great.
We need to have 4 or
We
5
need a quorum,
quorum.
yes.
Well, if we get it tomorrow afternoon, that gives us 6 days.
And then
I prefer to be here. That's not.
continue the hearing and go through this.
Continue the matter till next Thursday at 6:30. I'll move, we continue this evening's meeting till next Thursday at 6:30 PM.
That's all you need. Second.
And I think I hear public hearing, that you're continuing the public hearing, right?
Yes. That was exactly what he said.
Continue this. I said this
Okay.
meeting.
Any discussion? No comments, then if we could take a roll call vote.
Commissioner Brown,
Yes.
Commissioner Harvey,
Oh, yes.
Commissioner Kennedy,
Forgot it was
No.
Commissioner.
Commissioner Larson,
Yes.
Chair Hartsfield.
Yes.
Motion passes 4-1.
Okay, you're continued until next Thursday. On this item, let's take us to reports. Do we have anything to report from staff?
No.
That was the right answer.
I guess I'll just say that I appreciate that we're going to continue to speed this along, to move to the city council. And personally, I was not going to be available on October the 12th, our next. regular meeting.
Oh, okay.
So this will work very well with my schedule. I appreciate working these things
No,
out.
it's good that you did,
Getting
because
a
every one
draft
of
from
us is
Nina
necessary.
tomorrow.
Yes.
Yeah, quorum is important.
Very good. It's now 10:20. Meeting's adjourned.
Thanks, seeing everyone.
Thanks, everybody.
Thank you.